May I please, Lordship?
Wait.
I'd like to mention one review application.
Please wait for
matter.
a second. Please wait for a second. Items for delivery of order. At number 37.
Petition dismiss.
Item number 38.
Petition allows.
Yes.
Yes.
May I please, Lordship? I'd like to mention one review application matter, Your Honor. It may
When?
be listed on 29th or 31st of this
When
week,
do you want?
because it is more than two years old, Lordship.
When do you want?
It is on 29th or 31st of this week, Lordship.
29.
29, that is
29
31st
not
Saturday,
possible.
two
Not
working
possible.
days. Or maybe on 29th, Lordship.
Not possible.
Or maybe on
First week.
30th of this week. 30, 30.
No, not possible.
I don't, maybe in the next week, Lordship.
Next week, yes.
Because
Any date you can.
other side is trying hard to grab the land, Your Honor. The land is in my
Any date you can choose from him.
On 2nd September.
2nd September. Yes. Obliged.
May I please, Your Worship? So I'm the consent of other side, Milord. I beg to mention item number 40, Milord, 40. This matter is actually hearing matter, Milord. Last occasion it was in the column of hearing, Milord. And now today, Milord, is listed for order. So Lordship may fix at the convenient date that on 5th of September, Milord.
40.
440. 5th of September.
You inform the other side?
Yes, sir. I am for the applicant.
As agreed by learned advocates of both sides, registration list the matter on. When?
5th of September. 5th of September, Lordship. Also hearing, as a hearing matter.
In the hearing column. Yes.
May it please your Lordship. Lordship, with the consent of the other side, I beg to mention item number 26 and 27, Lordship. Lordship, this matter may kindly come out after 4 weeks, Lordship. I have taken the consent. In item number 26, I am for the respondent, and 27, I am for the applicant. Analogous cases, Lordship.
Okay. As prayed for by Mr.
SP Sharma, Lordship.
Learned counsel for the respondent in item number 26 and petitioner appellant in 27. The case is then adjourned to be listed on when?
Lordship, a date may be fixed after 4 weeks, Lordship.
After 4 weeks. On 30 September.
Obliged, Lordship.
The hearing matter.
Yes, hearing.
Met be your lord.
And on 1st
My lord,
October.
we have filed a revision application. Connected matter is fixed day after tomorrow, my lord. I only want that this matter may be listed tomorrow for the purpose of passing in order to tag the matter within it, nothing on merit.
My lord, I beg to mention one regular second appeal, my lord, RSA, my lord, number 280/2010. my
When?
lord,
When?
To come up for hearing on the 2nd week of September. That may be fixed, my lord.
On 9th September.
19th September.
Marriage. Well, in I civil division petition, I have filed an IA to vacate the stay order. That was listed on last 12th of August. So it may come on 4th night.
4 September is holiday. On 6 September.
May I please, Your Lordship? So with consent of the other side, Lordship, I would like to mention item number 19. The matter may come after 2 weeks also.
Well, date may be fixed because 11 it is probably is granted and on our persuasion we have
may
listed
be
this
fixed
matter, my lord. Now,
Item number 19.
19.
my lord, the date may be fixed, my lord, we may accommodate, no problem.
As agreed by learned advocates of both the parties, registration list the matter on.
On 19th September. Thursday.
Obliged. Yeah, please, ma'am. My lord, I beg to mention item number 29, ma'am. My lord, I'm mentioning on behalf of Mr. R.S. Misra, my lord, he has some personal difficulty today.
Item number 29.
Mr. R.S. Misra has some personal difficulty today, my lord, and the other side is there, my lord, and they want to fix
My
it.
lord, I pray that the matter be listed day after tomorrow, my lord.
Day after tomorrow, not possible.
My lord, actually, then
Lot of matters have been fixed.
an application for early hearing has already been filed and that has been allowed. my lord.
Maybe. But we have our limitation.
My lord, next Tuesday, my lord, on a hearing day.
We'll try. On the appearing made by Mr. Gupta, learned counsel appearing on behalf of Mr. R.S. Misra, learned counsel for the appellant with concern from the other side. Recess and list the matter when?
Third
Tuesday.
September, third September, Tuesday.
Obliged.
My lord, I have one another, my lord, one FAO, my lord, injunction matter, my lord. I am appearing for the respondent. I prefer list on if possible on Monday, my lord, second, my lord. 2nd September, my lord, for orders, my lord.
Okay.
Obliged.
May I please your lordship, for the listing of a RFA, it may come for order matter, if possible, 5th September.
Okay.
Lordship, 5th. Highly obliged, lordship.
May I please your lordship, with the consent of the other side, I beg to mention item number 25. Your lordship, my senior is out of station, so the matter will be passed over for 1 week.
You offer?
Petitioner.
I am for the respondent, my lord. Yeah, lord.
So as agreed by learned advocates of both the parties, recess and list the matter on
10th of September, my lord, 10th.
10th.
Me, please, your lordship. I pray for listing of civil revision petition, my lord. Any date next week on 6th, my lord.
Okay.
I'm on. May I please, your lordship? Listing for a IA civil. Please, maybe possible to 3-9.
3-9 may not be possible.
3-9,
It's a long pending, CRP 440 2016,
Maybe.
9th September.
9 September. Hello, please.
May I please, your lordship, I beg to mention item number 3, lordship, please, agreeing for the other side.
Item number?
3, lordship. Lordship, may kindly adjourn this matter for today and fix it on 3rd of September, lordship.
3rd of September.
Lordship.
Okay. As prayed for by learned advocates of both the parties, recess and list the matter on 3rd of September.
Obliged.
Hello, please.
Lordship, I beg to mention item 33 and 34. Kindly adjourn the matter for 2 weeks, lordship. 33 and 34.
Lordship, item number 33, I am appearing for the respondents, lordship.
Any objection?
No, lord.
No.
Lordship, matter may be fixed after 2 weeks, lordship.
As agreed by learned advocates of both the parties, recess and list the matter 33 and 34 after 2 weeks.
May I please, your lordship, I beg to mention item number 42 for adjournment as my senior Mr. S. Kennedy is out of station. Consent has been taken from the other side. Kindly matter may be taken up at 17th of September.
When?
17th of September.
You inform the other side?
I'm for the other side.
You. So, yes, your good name?
KK Medi, I am appearing on behalf of
Mr.
Mr. S.
KK Medi, learned counsel appearing on behalf of Mr. S. K. Medi, learned counsel for the appellant with concern from the other side, press for listening the matter when?
17th of September.
7th.
Lordship, there is interim order, may be
Till then interim order passed earlier shall continue.
deeply.
May I please, your lordship, with the consent of respondent, I beg to mention item number 28, lordship. This matter is listed on my mention, lordship, but lordship, my senior is out of station. So kindly matter fix after 1 week.
Your good name?
P. Sharma.
P. Sharma.
Yes, lordship.
Mr. P. Sharma, learned counsel with consent from the other side, press for listening the matter after?
After 1 week, lordship.
After 1 week. There is a lot.
May I please your lordship? Lordship, I beg to mention item number 2. Lordship, in this matter, my senior, Mr. A. Sutter, today he is out of station. Matter may be adjourned for today.
Pardon?
I have taken consent.
Any objection?
No.
As agreed by learned advocates of both the parties, recess and list the matter after?
My lord,
On 26th September.
maybe 25th,
No, not possible.
23rd, 24th, 25th, any date.
26th September.
Okay.
May I please, your boss? Lordship, I pray for listing, make appeal, lordship, any date next week. Deep level.
May I please your
On
lordship?
11th.
May I please your lordship? Lordship, I beg to mention for listing of one RSA matter, your lordship, next week. Lordship, I have one another prayer on behalf of MS Roy, your lordship. I have taken the consent of the other side. Item number 1, your lordship. For her medical treatment, she is out of station, your lordship. Matter may be.
Item
adjourned for-
number 1.
Yes, your lordship.
You are appearing on behalf of?
MS Roy, appellant, petitioner,
On the appear being made by Miss
FN Jaman.
learned counsel appearing on behalf of Miss S. Roy. You inform the other side
Yes, your lordship, I have
with
taken
consent from the other side, plus for listening the matter when
after 2 weeks, your
after
lordship.
2 weeks. Fair allowed.
Oblige, your lordship.
Lordship, with the consent from other side, I beg to mention item 7, Lordship. Kindly the matter may be taken up in the next week. I am for the respondent.
But your name is not reflected there.
But we have filed our wakalatnama, Lordship.
When? Ms. R. Saha, learned counsel for the respondent with consent from the other side, plus for listening the matter. When?
Lordship, there is wakalatnama the file.
When do you want?
In the first week of September.
Okay, first week of September.
May it please your lordship. Lordship, I pray for listing a pending MSc appeal.
When?
Next date.
On 13 September. 13.
Maybe lordship, I beg to mention item number 35 lordship. Kindly adjourn for today lordship. I have taken consent from the other side lordship.
My lord, and for the other side, my lord, we are for a degree holder, my lord, date may be fixed, my lord, on 19, my lord, on 19 September.
You are for the
Appellant lordship. Appellant lordship.
appellant. Mr. Your good name?
Yeah, Muslim lordship.
Mr. M. Hussain, learned counsel for the appellant with consent from the other side, press for listening the matter. When?
On 19, my lord, 19
19
September.
September.
Yes.
Okay, okay.
Maybe
Fair
lordship.
allowed.
Lordship, I have more another prayer lordship. I beg to mention for listing an MSc appeal lordship.
When?
Next week lordship.
On 13th September.
May I please, your lordship? My lord, I am praying for listing of my lord CRP IO, my lord.
When?
Friday, my lord.
Friday.
Next week.
On 9th.
May I please, your lordship?
Oblige.
Lordship, I beg to mention item number 4, lordship. Lordship, Youngest counsel is out of station, lordship. And it may be taken, lordship, on 3rd of September, lordship.
Who is the counsel?
Motiur Rahman, lordship.
Your name?
I am in lordship.
Mr. I Amin, learned counsel, appearing on behalf of Mr. M. Rahman, learned counsel for the accused. Press for listening the matter. When?
3rd September, lordship.
3rd of September. Okay, fair allowed.
Lordship, I have another prayer, lordship. I beg for listing a RSA, lordship.
When?
Lordship, any date next week.
On 11th.
Oblige.
Promotion item 39.
Mr. Dubey, you were for respondent.
Yes, I represent the Airport Authority of India.
Who is for the petitioner?
Mr. Das.
After
He has come.
Yes, Mr. Das.
Yes, my lord, this is a revision petition, my lord. We have challenged an order passed by the Learned Court of Civil Justice Senior Division, my lord.
Mm.
That order, my lord, is at page number 74 for non-consideration of our prayer for ad interim injunction, my lord. That page number 74. If your lordship will kindly see the facts of the case. May I state the facts of the case, my lord? If your lordship will kindly see page number 55.
8 minutes.
Yes.
For respondent number one, oh, are you?
My lord, Deputy Solicitor General, my lord. DYS.
But on the other day, Mr. D. Chakraborty appeared.
Yes, he's appeared. My learned friend is for the airport authority.
Hmm.
My lord, in those earlier, my lord, this matter was taken up on 2 occasions, my lord, but we could not get hold of the council for the airport authority, my lord. That is why, my lord, today it was fixed.
But today, both the council has to remain present.
Actually, my lord,
Mhm.
my lord, we have sought relief only against the airport authority, my lord.
But Union of India is
Yes, yes.
so we'll take it up after some time. In the meantime, Court Master will inform Mr. Chakraborty.
Highly obliged.
For bail hearing, item number 5. For bail hearing, item 5.
Lordship, my senior lives in another court. Please,
Who is your senior?
Lordship,
Who is your senior?
Mr. SCKM.
Item number 6.
Thank you, Your Lordship. Lordship, as per the last order, steps were required to be taken, the informant, Lordship, steps were taken as per the.
As per the instruction from the IO lordship, notice was served yesterday, lordship.
Where is the proof?
Look, that it was verbal telephonic communication, lordship. I have received, yes, morning I have called him, lordship. He has given a copy of in WhatsApp, lordship. So, lordship, my humble prayer is that fix it another date, lordship, where he has produced some documents that notices served, and they will be fixed on that day. And another thing, lordship, we have to go through our reports also.
Heard, Miss?
And Begum, Lordship.
Learned counsel for the accused and Mr. Goswami, learned additional PP for the state respondent. Mr. Goswami submits that he has received instruction from the officer in search jurisdictional PS that notice upon the respondent number 2 is served. But he has not received any written report and therefore prays for listening the matter. When?
Lordship, could it be on 29th?
29. 29.
I thought.
Fair is accordingly allowed.
Item for hearing under order 41 rule 2 CPC. Item number 8.
Nine. Jay Ahmed. All of dedicated time. All of the hate. Jay Ahmed ahead.
Item 9 for orders.
The matter should be fixed for final hearing. They themselves admitted that the respondents upon whom the service has not been made were not contested in the trial court. They themselves admitted in the substitution application itself. They have not contested at any point of time. Unnecessarily, the matter has been deferred. Let a date be fixed for final hearing. There is no embargo, no bar for fixing the matter. The record is otherwise ready, the case is otherwise ready. They themselves admitted in their application for substitution dated 28th October 2013, paragraph 6.
Paragraph 6 of?
Paragraph 6 of the application for substitution dated 28th October 2013 in the substitution petition filed by the appellant themselves. In paragraph 6, I am for the respondent. Also on that side, however.
I'm appearing for the appellant.
Okay.
Acha.
Please,
So I'm fixed.
I'd just like to complete my submission.
Come this side, no problem.
No matter.
I was little confused. I said the matter is speak for order, Your Honor. As per Your Honor, as per the office note, Your Honor, the service upon respondent number 2, 3, and 4 has not been completed. And as you know, that we have already taken steps, and as per my instruction, it is the address, address is correct, but it has not been accepted, so we are going for newspaper publication if this court permits, Your Honor. To take steps, because as regards respondent number 1, he has already appeared, Your Honor. So if this court permits, then we have no objection if the matter speaks for final hearing, but as regards since steps upon respondent number 3, 4, and 5 has not been completed, Your Honor. So, but they are all the members of the same family, Your Honor. That is a fact, Your Honor.
All of us are of the same family.
So if they have no objection that if he is appearing for on behalf of all the respondent, Your Honor, the matter will be fixed for hearing, Your Honor.
Are you representing all the respondents?
No, how can I appear? Because I am the plaintiff,
No, because
the
you,
sole plaintiff.
no, he in this trial, so he is the sole plaintiff, Your Honor, but here he is the respondent. Now, if since he is pleading for a final hearing, either he has to represent all the respondent or the steps has to be completed, Your Honor. Service has to be completed for other respondent. And if he represents the all the respondents, then I have no objection, then matter will be fixed for hearing. Your Honor.
Your Lordship, the law provides order 41, rule 14, sub rule 4. Your Lordship knows very well the particular provision. It is very clear to this particular respect. Notwithstanding anything to the contrary contained in sub rule 1, it shall not be necessary to serve notice upon any proceedings incidental to an appeal on any respondent other than a person impleaded for the first time in the appellate court, unless he has appeared and filed an address on the service in the court below in the first instance, as appeared in the appeal. So no need of service notice. They themselves admitted that these respondents have not contested in paragraph 6 that the other legal heirs, that is opposite parties, did not contest the probate case, so they have not filed any appeal against the judgment and order dated ato. So they have been made as opposite parties in the petition in appeal. They have been only made party as a matter of formality, since they have been made party defendants in the court of the first instance. Your Lordship, kindly look into the order since 2019, 1st March 2019 order passed by your Lordship. 2019, 1st March. Third, Ms. Bhattacharjee, learned counsel for the appellant, and Mr. Terangi, learned counsel for the respondent number 1. It is submitted by Ms. Bhattacharjee that steps on the respondent number 2, 3, and 5 were taken on 28 February 2019, registry to verify. It is submitted by the learned counsel for the respondent number 1 that no enclosure except the appeal memo, whatever the thing may be, for the appellant next 1 week, list this matter on 1st April. So from that time onwards, since 2019, it is now we are ending in 2024.
In that case, I
For
don't have
no
any
reason
objection if the
whatsoever.
matter is fixed for hearing, Honor.
Yes.
If the court is ready to take up the matter without serving things completed on the other respondent, I have no objection.
In
to that, Your
respect
Honor.
of a will probate matter, it is the prerogative of the parties who may come up to contest, who may not. That's their prerogative. They serve notice, they have not interested to contest in the trial court. So there is no embargo, no bar to keep the matter pending unnecessarily for serving notice.
Okay,
to
okay.
contest.
Heard Mr.
Yeah, Leon.
AI Ali, learned counsel for the appellant, and Mr. Your good name, please.
Sarangi.
Learned counsel for the respondent. It is submitted at the bar that the matter may be fixed for final hearings. Accordingly, it is provided that recessal is the matter for final hearing on COVID.
Okay, on 1st October, Tuesday,
Short date.
September last week on
1st of,
So any Monday, if your Lordship time
Monday.
permits, any Monday.
hearing matter is on Tuesday,
Acha, Tuesday, okay, all right.
26 September.
I'm getting. I'm getting.
Plus.
Item number 10. Item 10.
None appears for the appellant on call. applicant confirm recusal is the matter after. None appears for the applicant confirms. It appears that on 12/8/2024 and 3/6/2024 and 2/5/2024 and 19/4/2024 and 28/6/2024 the applicant remain unrepresented. Today also, none appears for the applicant on call. In view of above, this IA stands dismiss or non-persecution.
Item 11.
Okay, we ready to have one.
May I please vote, my lord? In respect to respondent number 12, service report is awaiting mail. And so far as the postal service are concerned, notice was duly accepted by the court by order dated 24/7. And lordship kindly have a look, office note dated 21/8/2024. I'm sorry. Okay. David can order. David careful. Yes, sir. Oh, nice then. I wait.
So you have taken a step upon respondent number 12.
Yes, yes. As per the order dated 24/7.
You have taken a step by registered post.
Yes, yes.
Can you track it?
Yes, yes. Yeah. On note of Now we have taken step on 57/2024. By the report to get it.
Part Mr. Professor, learned counsel for the petitioner. Office note dated 21/8/2024 indicates that service report in respect of respondent number 12 is still awaited. So list the matter after 1 week awaiting service report upon respondent number 12.
And interim order, my lord, may be allowed to continue.
Till then interim order pass earlier shall continue. Rest shall track the
Hello, let
rest
it
shall
come, my
put up one up to that office note.
Hello.
After tracking the same in the website of the postal department.
My lord, let it come, my lord, after, my lord, any date after 10, my lord. I'll be out of station.
Okay.
On 18 September.
My lord.
Item 12.
Eight, please, your lordship. As per order dated 12/8/2024, service is complete, your lordship. But till now, there is no representation by the opposite party. Your lordship can fix the matter after 2 weeks. Let them appear. They might have objections regarding the delay, your lordship.
Heard Mr. S. Dr. Learned. Counsel for the applicant. None appears for the respondents on call. As tried for by Mr. Dr. raises a Lisa matter after
2 weeks, your lordship.
after 2 weeks.
Much of.
Item 13.
Lordship service is complete and LCR also received. My submission to be Lordship, they have filed an application for withdrawing the amount that is deposited in government employee is receiving salary till date of retirement. So already Supreme Court has decided the matter and law has been settled. That loss of dependency, as this is was the date of the deceased Lordship, they are receiving the full salary till date of retirement with all increments. That is why they are entitled only for the conventional head, loss of life and everything. So Lordship will decide the matter at any date. Lordship may fix this matter for final hearing because law has been settled by the Supreme Court. LCR also received.
Lordship will fix the matter, my lord, because out of 50, my lord, award is of 50,13,000, my lord.
We have
Award,
proposed the
my lord,
12 lakhs.
award is 50,13,000 and my lord, this honorable court directed to deposit rupees 12 lakhs, my lord.
As per our submission.
So this will be about, my lord, 10% to 22%, like that, my lord.
In case of government employee, Lordship is aware the Supreme Court has clarified their position because loss of dependency is they are not entitled. Because as per notification issued in 2017, government employee died before retirement, he will get full salary. till retirement.
What was the quantum of compensation?
Quantum of compensation, Lordship will find
50,13,368.
And you have deposited 12 lakhs.
12 lakhs.
Now you want to withdraw it.
Yes. But I have not filed any IA till
They have
now,
to
my
file
lord,
IA
because,
on Lordship and dispose this matter. There is no IA to that effect for withdrawing the money. Lordship may fix this for final disposal.
Okay.
Because LCR also received, service also complete. As per his
Heard
convenience.
Mr. S.K. Goswami, learned counsel for the appellant, and Mr. A.K. Gupta, learned counsel for the respondent. It is submitted at the bar that the matter is ready for hearing and the LCR has also been received. Accordingly, it is provided that races will list the matter on Kabir Trend.
First week of October,
Sorted
September, then 26 September.
26 for hearing.
Item 14.
Lordship, IA 424 Lordship, the delay coronation Lordship, the 703 days delay Lordship. So the interim order passed by the subordinate court Lordship is land civil judge Kukrasa Lordship. And the Lordship, I have stated in the para number 6 Lordship in the delay Lordship. So the due to the negligence of the council Lordship, so the interim order has passed of the expert. Lordship, kindly see Lordship, the PS 22, the internal page of the judgment Lordship, PS 22 in my IA Lordship, 424/2024 Lordship, 22 Lordship is the internal page of the judgment Lordship. Married Lordship, and my Lordship. Column number 15 Lordship.
Page number?
Page number 22 in IA Lordship. Column number 15 Lordship. Kindly find my internal page is the 19 lordship. 18 column number. May I read lordship from perusal lordship?
No,
From
the pagination is not correctly made. You are referring to,
IA lordship 424,
yes, 424,
page number 22 lordship.
page number 22, yeah,
Is a
is the part of the judgment.
Yes, lordship, it's a part of the judgment lordship. The from perusal lordship, column number 15 lordship.
Yes,
For perusal, merit lordship. For
yes,
perusal, the entire evidence of the plaintiff, it appears that the plaintiff is also able to prove his case by adducing oral and documentary evidence. The defendant side, though the appeared before this court, but they did not file their written statement and did not contest of the suit lordship. The defendant side, though their learned advocate filed hazira, but they did not argue of this case. The several opportunity given to the defendant, but the defendant did not able to contest his case. The considering the above evidence on record and the exhibited documents, this court is believed that the defendant miserably failed to comply the agreement dated 1/9/2008 lordship and failed to repayment outstanding so. But whatever lordship, the counsel lordship, the defendant counsel lordship, that did not appear lordship. So ex parte degree was passed lordship. That did not contest lordship. The contest of the suit lordship. So lordship and another issue lordship. So the counsel did not inform lordship. So that's why the delay has 703 days lordship. I have written para number 6 lordship in my delay picture. Para number 6 lordship. My high lordship. Page number 9 lordship. Merit lordship. Page number 9 lordship.
yes,
That the applicant best is that the engaged counsel of the applicant, the defendant has misled and the negligence to conducting before the learned trial court. Despite the learned counsel does not instructed to the applicant to file the written statement, affidavit on the defense prosecution and the adduced evidence exist before the learned trial court. Therefore, the impugn judgment and decree inasmuch added ex parte on 12/9/2019 lordship. By learned civil judge Kopraja in height Manisut Nong 11/2013. Reason behind the negligence part of the counsel, despite the learned counsel also appeared there, that did not inform to the layman applicants till 1/7/2023, while the applicants came to know on the in respect of this impugn judgment and decree, as well as the applicants immediately came to know the learned court below 7/7/2023. Therefore, they applied certified copy of the said impugn judgment and decree dated so the same day, as well as finally the detailed judgment and decree received on 11/7/2023. The subsequently applicant approved and conducted the counsel of the trial court to raise their all grievance for the negligence to delay information in respect of the said judgment. The land counsel suggested to the approach before the Honorable High Court so. So, lordship, what happened here in this case, lordship? So the delay, the negligence part of the counsel. So therefore, the counsel did not inform to the applicant lordship, applicant. So the delay has caused lordship. So that there is no willful and deliberately delayed by the part of the applicant lordship. And lordship, I have lodged one complaint lordship in the against the counsel lordship in the 4th additional affidavit lordship. I have lodged a complaint lordship in the 4th additional affidavit lordship. I have one complaint with the negligence of the counsel. In the 4th additional affidavit lordship.
4th additional affidavit is not here. Yes, Mr. Deka, what is your submission?
First and foremost, my lord, if your lordship peruses the judgment, my learned
The
friend is
expert
submitting
is husband.
the judgment which my portion which my learned friend has read, my lord. If your lordship kindly turns to page 19. My lord, the entire case is that it was passed ex parte. But if your lordship peruses the judgment, the counsel for the applicant has appeared at every stage. Even on the day of the hearing, he had appeared and filed hazira. Paragraph 11, page 19, my lord. Internal page 6. 5, my lord. No, 6.
Para number 11.
Para 11.
Yes.
Defendant side failing for filing written statement. Lordships have got it?
Yes.
And case has been pending since 10/10/2013 for filing written statement by the defendant side. The defendant side filing one after another petition telling the suit. On 24/9/2015, the case was fixed for filing written statement by the defendant. Thereafter, defendant filing petition one after another and seeking time, and ultimately on 13/11/2015 filed a petition for conciliation of this case. Accordingly, case was proceeded in mediation center, but no conciliation, and settled the matter till today. But defendant side failed to file written statement since last several years. It is having a long period and statutory period already over. Today, learned advocate for defendant has filed hazira. Today means on the date of hearing. No steps taken by the defendants regarding negotiation of this case. Hence, case is fixed for filing affidavit of plaintiff side. Plaintiff is directed to file their affidavit on the next day positively. The defendants are getting chance for several times argument of this case on the law point, but failed to argue this case on several dates. On 6/9/2019, heard argument for the side of the defendant and plaintiff at length. Defendant failed to argue this case, hence the case is fixed for judgment. Now, my lord, if your lordships interferes, the clock will have to go back to 2015, my lord. They will now have to be permitted to file a written statement, then evidence. Or what about the period of 90 days, my lord? It is long over. And the entire blame is on the advocate, and my learned friend has now placed the affidavit where a complaint is registered before the Bar Association, my lord. Bar Association is not the appropriate authority. He has to register a complaint before the Bar Council. It is the Bar Council who can take disciplinary action. The Bar Association at best can say that we will debar you from being a member of our association. Disciplinary action the Bar Association cannot take, my lord.
No, that is not the subject matter before the court.
No, my lord, the entire ground for delay condonation is the advocate's default. If your lordship.
No, but it appears that the council had entered appearance and filed hazira.
Yes, my lord.
Not argue lordship. So here
Who is to be blamed, my lord? It is not that the council did not appear.
Did not contest of the suit lordship. So due to the negligence, absolute lordship of the council.
No, the matter was sent to the mediation center also for conciliation.
And lordship, the Honorable Supreme Court held lordship the latest judgment lordship. So litigant should not be suffered due to the negligence of the council lordship. So another aspect lordship is the arbitration clause. One agreement was executed lordship. So there are volume number 19 which is clearly defined. If there any dispute, the arbitrator will be decide in this regard lordship. So here agreement also had lordship, the volume number 19 lordship, and that part also is not decided by the subordinate court also. So arbitrator court will decide regarding the suit lordship. So ex parte degree was passed lordship.
It is not ex parte, my lord.
Lordship
It's
did
not
not
ex parte
contest, which is clearly defined lordship, we have column number 15 lordship, did not contest lordship of the suit.
My lord, if the council appears and does not argue, my
No,
lord.
it cannot be said to be ex parte judgment.
So ultimately lordship, not a single time as FBR or argued this matter lordship. So ultimately did not contest, has clearly defined the subordinate court lordship. So lordship, I may allow to lordship the conduct delay lordship.
No.
1500 days delay, my lord.
No lordship, the 700.
1500, my lord. Lordship will kindly look at the cost title, my lord.
Lordship, in the Corona period, lordship, the 1 year already excused lordship. So on that basis, lordship, the register has calculated the delay lordship. 703 days delay lordship. Lordship, another Supreme Court judgment lordship, the so far concern of the delay lordship, the Shivraj Singh lordship, the latest judgment lordship. So the discretion power of the honorable court lordship.
No, that's all right.
So far concern the delay. The latest judgment of the Supreme Court lordship.
Okay, we'll see. You produce the judgment before the court. We'll see. We will pass the order.
Yes.
Para number 29.
Citation 29.
Yes.
Yes.
Item 50.
Pass over.
None appears for the applicant on call. Rest is the matter after 2 weeks. 2 weeks.
Sixteen and 17.
Mr. K. Gogoi is on Lakes Lordship. He is assisting Mr. A.G. Lordship, Learned A.G. Lordship in a matter in court number 1. So matter may kindly be taken up after 2 weeks Lordship. May I appear?
After
2 weeks Lordship. Or after 1 week Lordship.
Lordship, in this matter, already 5 times the adjournment has been sought by the learned counsel, and 1 or 2 times there are 2 cases. In one case, there are 4 to 5 times adjournment sought. In this one case, 1 or 2 times already sought. They are
so
repeatedly
let
taking
him come in the second half
Lordship,
at 2 p.m.
some part hard matter is also there Lordship. So,
Maybe,
Lordship,
but
urgency-
it was fixed today on his request.
Yes, Lordship. Lordship, urgency
Sorry.
is on our part.
No,
Urgency
let him come at 2 p.m.
Lordship, urgency is on our part. They have not filed even execution petition. also.
We will see.
Repeatedly adjournment.
Because we have filed.
Let
we-
him
we
let
have-
him appear at 2 p.m.
Much obliged, Lordship.
41. Item 41.
None appears for the applicant on call. Rest is unless the matter after 2 weeks. 1 week. After 2 weeks.
$43.
My lord, these 2 IA has been filed, my lord, one for substitution of the legal heirs of the claimant, my lord. And second is for delay of condonation. My lord, the opposite party number 1 has appeared in the year 2019. But during course of hearing on 22/5/2024, my senior friend has informed the honorable court that the claimant has died. And therefore, after some days, the detailed particulars has been submitted. And accordingly, I have declared this IA for substitution.
Yes, madam.
My lord.
I think in the meantime,
In the meantime, my lord, respondent number, my lord,
husband of the
claimant
also
also,
expired.
claimant also expired, my lord.
So I may be allowed to stuff up the name of opposite party number 2, and the opposite party number 1 will be the daughter of the claimant.
Heard, Mr.
Answer.
Learned counsel for the applicant. This application is preferred by the applicant. Siri Dulu Sarkar for substitution of legal heirs of the deceased, respondent number 1, who suffered demise during the pendency of the instant appeal. The learned counsel for the applicant submits that the respondent number 1, when he suffered demise,
21/5/2019.
1/5/2019. 1/5/2019.
21/5.
21/5/2019.
21.
21/5/2000.
Where is the certificate? certificate have not been, but they have provided to me.
I have provided, my lord, unfortunately.
It's not enough, it is admitted. 21/5/2020. Twenty-one, 5/20, 19. 2019. Leaving behind her husband and a daughter. The learned counsel for the applicant has also produced one death certificate of the respondent number 1. And it appears that the respondent number 1 suffered demise on 21/5/2019. Having heard the submission of learned advocates of both sides, this IA is since allowed. The legal heirs of respondent number 1 be substituted in the MSc Appeal number 280 of 2019.
My lord, the respondent number 2, my lord. My lord, he
Husband of-
also husband of the claimant, my lord. He also expired, my lord, on 9/12/2024, my lord. Unfortunately, I got the.
But without any
my-
prayer and without any document, let him take step.
my lord,
The
I
learned
provide-
counsel for the respondent also submits that the husband of the respondent number,
2, my lord.
Claimant. Respondent number 2.
I may be allowed to stop off, my lord. You have submission made by the, my claimant. Because before filing
Respondent
of this,
number 2.
opposite party number 2, that may be stop off.
Respondent number 2 also suffered demise. And the learned counsel for the applicant submits that he may be allowed to strike out. Submits that the name of the respondent number 2 may be struck off from the array of this application. And the array in the MSc appeal number so and so says. There is accordingly allowed. Recessal is the matter when after
1 week or 2 weeks, madam.
after 2 weeks. After 2 weeks.
Like next petition for condonation of delay.
Well, we have to file objection, my lord, in this regard, so 3 days time may be allowed, my lord.
In I number 2495.
98. But subscription has been allowed, then what remain, my lord, for filing delay condonation? It is not fault for me, my lord, because the learned counsel for the opposite party has informed before this honorable court in the year 2024 that the claimant has expired, and accordingly we have filed this petition for condonation of delay for submission for filing of the substitution petition. Since your lordship has allowed the substitution petition, so what remains in the delay condonation petition is not for our part delay negligent.
No objection in the delay condonation. Since I also received the information regarding the death of the husband of the claimant, my lord. That is why I could inform the petitioner very late, my lord.
I got the detailed particular in the month of June 2024 and accordingly filed thereafter.
So this IA become infructuous.
Yes.
Pardon, sir. and Sarma, learned counsel for the applicant, and also Hartness, also learned counsel for the respondent. It is submitted at the bar that in view of order passed in I number 2498 2024, the
2495.
application become
2495.
98.
98.
This application become infructuous and accordingly the same instance closed.
And by the delay also.
Bobby, next.
Obligation.
For hearing, parted matter. At number 18.
Ma'am, sorry, my lord, item number 15, I have missed, my lord. Sorry, ma'am.
Item number?
15, my lord, it is the order matter, my lord. I'm sorry, ma'am, I have missed the matter. 15, my lord. Other side also, my lord, she was. It, my lord, IA was filed, my lord, for early hearing, my lord. And definitely disposed of it. Because, my lord, second appeal again.
Let it come at 2 p.m. then.
Obliged.
Item 18, parted matter.
Lordship, I apologize. Lordship, item number 41, we could not appear on time.
Sorry, order has already been passed.
Lordship, there's an interim order, if you could just extend that.
Punarfil. Okay, interim order will continue. Yes.
Item 18.
Lordship, I have gone through the judgments, Lordship. The Mohanlal, then Asif judgment, and Mangilal, and one Simranjit versus State of Punjab, Lordship. Here, Lordship, the seizure, those were, Lordship, waited at the place of seizure, which is actually, as per the rule, Lordship, is not proper. It has to be waited in front of the magistrate, Lordship. Those were
No,
not
whether that
proper.
inventory was prepared.
One pink flag is there, Lordship, but it is neither exhibited nor
Inventory is prepared, Lordship, but.
No, whether it was prepared before the magistrate.
it was not prepared, only it was produced. This inventory says that kindly go see, this is the seizure items. That much was done by the IO, Lordship. Already it was weighted and said that 4 kilogram and 800 grams of ganja are there. Kindly see, that much is there. But it was not seized as per the Act, Section 52, Lordship.
That is the inventory, Lordship, that has been prepared, but it is not exhibited, Lordship.
Not
It is
exhibited,
prepared, but
nor
it is not
certified.
exhibited, Lordship.
No, can it be said that the direction given in the case of Mohanlal is complied with?
No, it's not complied with.
Yes.
That inventory is not exhibited, Lordship.
Then
Seizure was made on the place of occurrence. And the IO's evidence is silent about any such.
away. Evidence.
PW7 is the IO.
Because evidence, Lord.
Now, whether the seized articles were produced before the court at the time of examination?
Production possibly perhaps not there, but only thing is that that inventory says that these are the document, kindly see, that much was there.
That is not
See,
mentioned, Lordship, that is not mentioned in the evidence, Lordship. That
because
that
IO's
is-
evidence doesn't reflect anything, and this is not exhibited. That document inventory is not exhibited, neither IO had given any evidence regarding that. But there was one, the pink flag is there in the original record, which is not a part of the paper book also, Lordship, because it is not an exhibited document.
So, Mr. Lofer, have you gone through the two judgments she has referred to?
Mohanlal Lordship, I have control Lordship, wherein it is said Lordship that inventory is mandatory Lordship.
Hmm.
And other judgment I have no control.
Others also discuss Mohanlal's. Mohanlal is the base case. Other judgments on the basis of the law laid down in Mohanlal's case.
So the inventory is prepared but not exhibited before the trial court.
Yes, Lordship.
And number two, this provision of section 52 capital A is not complied with. So what would be the consequence of non-compliance that has been discussed in the two case laws?
Yes, Lordship. 52 is mandatory, Lordship, as per this Simranjit and Simranjit Singh versus State of Punjab.
Any other point?
And other grounds, they are also not
So sampling was done before the magistrate or
no,
at the
Lord,
place of
at the
occurrence?
place of occurrence. At the place where it is seized, Lordship.
So these seized articles are not produced before the trial court.
Lordship. From the evidence, it is not produced.
Art Miss B. Sharma, learned counsel for the appellant. No, learned amicus curiae for the appellant, and Mr. E. S. Law Court, learned additional PP for the state respondent argument concluded, judgment reserved.
Item numbers 20 and
Right.
21.
Yeah. And there are two appeals
Hmm.
arising out of same judgment,
79 and
80.
80.
arising out of the same judgment actually. Initially, the suit was filed by the plaintiff against two sets of defendants. After this suit was decreed, two sets of different defendants were filed two separate appeals.
Mm.
And both the appeals were dismissed as against the two second appeals have been filed.
So you are for the appellant,
I am for the appellant. Mr. B. Deka is appearing for the respondent.
Mr.
B. Deka and N. Bora.
Are they available today? What's it?
I'm appearing on behalf of Mr. N. Bora. Please appear on for respondent number 3, 4, and 5. Lordship, please.
What's up? You were ready?
Lordship, please should come. Lordship, I've informed him he will be available. I'm on the data card. The Lordship, you may fix it. Lordship.
Pardon?
Lordship, my senior is just he will address Lordship.
Okay.
Your Lordship, if your Lordship written Lordship may fix the matter, Lordship. Some other Lordship, it's my.
Why?
See, my senior is also in Lakes, Lordship.
No, maybe. Yes, Mr. Mazumdar.
I leave it to your lordship, otherwise I am ready.
So any other. And
Can you take it up
Pardon?
at 2 or any other?
At 2 today.
My
Okay, at 2 that.
Or I may start. They will.
Okay, start then.
Yes. My lord, this is I'm for the defendant, my lord. Plaintiff lordship will kindly paper book RSA 80 of 2014 lordship may kindly take up, my lord.
Yes.
My lord, page 43 is the plaint.
Then RSA 80.
Lordship will work on page 43 is the plaint.
Yes.
My lord, lordship may kindly turn to page 52. What is the relief they have prayed for? Lordship may kindly have a look. Page 52.
Yes.
Page 52, my lord.
Mm.
Plaintiffs pray A, that the decree be passed declaring that the plaintiffs and the pro forma defendant number 6, 7, and 8 have right, title, and interest over the suit land. And the the decree be passed declaring that neither the defendant nor the predecessor or transferor in interest were tenants in the suit land under the plaintiffs or the pro forma defendant number 6, 7, and 8 at any point of time, and that the defendant is not tenants under the plaintiffs or the pro forma defendant number 6, 7, 8, and that they have no title to occupy the suit land. And C, this is important, that the decree be passed declaring that the grant of ownership right by the Additional Deputy Commissioner Barpeta to the defendant by order dated 9/5/2023 in TR case number 1 of 2002-2003 and also the entry of the name of defendant as tenant in any revenue record as claimed by the defendant are ultra-virus, illegal, fraudulent, and inoperative in the eye of law.
Sorry to trouble your lordship in the midst of the hearing, my lord. My lord, today it'll be a little difficult on our part to do our part, my lord. There are two appeals. If your lordship may accommodate us, if your lordship wants to hear their side and keep it as part heard. But today it'll be a little difficult for us to argue our part.
Let him complete his part then.
Next week, madam, it's this, madam, next week.
Let him-
Or what, Tuesday.
Let him complete his part. Yes.
Then next page, my lord. Prayer D. That a decree be passed to deliver khas possession of this root land in favor of the plaintiffs by evicting the defendant and everybody claiming through him and the cost of the suit, etc. Now, my lord, this prayer relief they have sought, my lord. Number one is the declaration of title. And number two, that the defendants were not tenant. And number C is that the grant of ownership right by the ADC Barpeta on 9/5/2003. What has happened, my lord, the plaintiff's case is that they were never any tenant. And in fact, earlier there was a round of litigation before the revenue authorities, which reached up to this on the court after the judgment was passed by the revenue board, challenging this particular order. And thereafter, the suit has been filed. Now, what I am saying is, my lord, during the at the time of admission of the regular second appeal, certain substantial questions of law were framed, which your lords will find at the very second page of the memo of appeal, my lord. While admitting, my lord, on 12/7/2016, these four substantial questions of law were framed. Number one is whether an occupancy tenant under the Assam Temporary Settled Areas Tenancy Act 1971, whose name is duly entered in the Khatian Patta, can be ejected from the land under his occupation, derogates the provisions prescribed by Section 51 of the said Act 1971. And Section 51 of the Act provides for prior notice before any eviction suit is filed. Number two is whether the civil court is vested with the jurisdiction to nullify the entries made in the records of rights and in the matter of maintenance of record of rights, notwithstanding the bar imposed under Section 66 of the Assam Temporary Settled Areas Tenancy Act 1971. And then three, whether under the Assam Temporary Settled Areas Tenancy Act 1971, an occupancy tenant enjoys a permanent, heritable, and transferable rights of use and occupancy in the land of his holding. Number four, whether
Yes, all these fours were framed in the.
oh yes, on 9/8/2022, madam.
9/8.
2022. Order dated 9th of August 2022. I'm sorry, madam. No, this. These were framed initially at the time of admission.
Yes.
Now, subsequently, when the matter came up before Home Justice Devashish Barua, madam, on 9/8/2022, another subsequent question of law was framed, and it was framed by the Honorable Court itself, madam, which your lordship will find in the order dated 9/8/2022.
Yes, the first order of admission, that is.
My lord?
The first order.
Yes.
By which the second appeal was admitted. It was passed on.
12th of July 2016, my lord. 12th July 2016, my lord.
It is not there in the
Possibly it is.
RSA 80.
I think possibly it was passed in RSA 79.
79.
My RSA. Issues are absolutely same in both the cases, so it might have been framed in RSA 79.
Yes.
Lord has got my.
Yes.
Now subsequently, when the matter came up on 9th of August 2022, additional substantial question of law was framed. Lord, you may kindly have a look at the order dated 9/8/2022.
Yes.
Upon heard Mr. So appearing on behalf of the appellant, non-appeal for the defendant. Upon hearing the learned counsel for the appellant, this court frames an additional substantial question of law in the instant appeal, whether the suit was maintainable without the state of Assam or the authority granting ownership to the defendant by the order dated 9/5/2003 in TR case number so made a party in the suit. In the plaint, if your lordship looks at the plaint, state or the authority which granted this ownership right in exercise of power under section 23 of the 1971 Act was not made a party. Lordship will kindly have a look at the copy of the plaint, my lord, at page 12. Page 12. I'm 43. I'm sorry, 43. 43.
In which item? 79 or 80?
80, my lord. 80.
80. Page number?
Yeah, page 43.
Yes.
Lord, admittedly, page 43 and 44 will show, my lord, that state or the authority which passed this order is not a party. My lord, what has happened in this case, my lord? Your lordship is aware, under the 71 Act, there is a concept of occupancy tenant and non-occupancy tenant. If a tenant remains in possession, occupies the land for 3 years or more, he becomes a non-occupancy tenant. Occupancy tenant, I'm sorry. As a result, my lord, section 23 provides that if an occupancy tenant applies for ownership, he can be granted ownership right. And accordingly, this is the order which they have challenged in the relief portion, my lord, in a prayer C. The order was passed by the Additional Deputy Commissioner on 9/5/2003, granting ownership right in terms of section 23 of the 1971 Act. Now, on the last question, when the additional question of substantial question of law was framed, the honorable court, my lord, was of the view that the prayers which they have made, although the first prayer is a declaration of title, but unless prayer C is granted, the question of declaring title will not come up, because title has been given to the defendants by virtue of this order of 9/5/2003 by the ADC. Now, unless that order is set aside, the question of granting a decree for declaration of title, my lord, cannot be granted. Now, in order to grant that relief, my lord, the authority which passed the order has to be made a party, it's a necessary party. In that view of the matter, my lord, for non-joinder of necessary party, this substantial question of law was framed. Now, my submission before lordship is on merit. I can take your lordship on merit of the case, but otherwise, if this substantial question of law, that if the state is not made a party and therefore the suit is not maintainable, then on this point itself, the appeal can be decided. This is what I'm saying, subject to what my learned friends say, my lord. For that, my lord, immediately, my lord, no argument is necessary. Plaint itself is very clear. The state or the authority, that is the ADC, who passed the order, are not parties. So, my lord, they are. In the written statement, lords will find page 55, the written statement starts.
Yes.
And page 56, my lord, paragraph 6, we have taken the plea of non-joinder of necessary party.
Para number?
6 on top, my lord, page 56.
The suit is non-joinder.
My lord. Suit is non-joint of necessary party. Suit actually is, our contention is whether suit is bad for non-joint of necessary party. Now.
So, can we decide the appeal only on the basis of the fourth substantial question of law?
My lord, the last substantial question which was tabled on 9th of August. My humble submission, because lordship is subject to what your lordships may say, that if the suit is found to be not maintainable for non-joint of necessary party, then other points need not be
Redundant.
That is my submission. Otherwise, I will go into all other questions also, my lord. But this point, if decided in favor of the appellant, that the suit itself is not maintainable.
Yes, Mr. Decker.
Good, that I'll subject to what my learned senior says, Manoj. I'll respond to that, Manoj. I would say non-joinder is not an issue here. Because in the written statement also, they've made a bold statement that the suit is bad for non-joinder of necessary parties. It doesn't specifically state which is the necessary party which has been left from the array of parties. Which is why such a plea of non-joinder, if raised for the first time at an appellate stage, I will definitely be taken by surprise. So that therefore, I think there are authorities which suggest, I'll of course look into it, which suggests that the plea of non-joinder should also be specific. I mean, they must specifically say that it is the state or the deputy commissioner or some other individual who was not arrayed as parties, and therefore it is bad for non-joinder. And this, though the substantial question of law was formulated, my lord, I think there's no corresponding ground in the memo of appeal. So, subject to what my learned
No. That question was a frame after hearing learned advocates of both the parties.
Unfortunately, we were not present on that particular day.
You were not present.
We were not present. Of
Yes,
course,
Mr.
that's
Mr. Mazumdar, is it correct?
My lord, on that day, my lord, the order itself shows that they were absent.
So then we hear the matter on merit. Mr. Mazumdar?
My lord, I'll satisfy your lordship that on this ground itself, the appeal can be decided. Your lordship will decide the other issues. Because, my lord, this is an issue. My lord, this is an issue. My lord, the plaintiff must show that his suit is maintainable. Defendant needn't come forward. There may be a case. There may be a case that in the facts of the case, I say that it is bad for some other, it's bad for non-joint necessary party. And on merit, I show that it is because of this fact that the suit is bad for non-joint necessary party. In that case, the question of leading evidence may come. But here is a case going by the plaint prayer. The relief you have prayed for is striking out or cancellation or declaration or declaring an order as null and void. Now you must satisfy the court that your suit is maintainable on the bare reading of the plaint. Now your plaint prayer for declaration of title can never be granted unless you get an order or decree that the order passed by the ADC declaring title in my favor in accordance with section 23 of this 1971 Act is bad in law. Unless they show that it is bad in law, they cannot get a decree of declaration of title. Now, in order to pray for cancellation or declaration that this order is bad, they must give an opportunity. That is why the Supreme Court says they must give an opportunity to the state to justify their order, or the authority who passed the order to justify their order. Otherwise, they cannot get a decree. Now, a person comes to the court and his suit is barred by limitation, he plays for a decree of 1 crore. Will the court granted only because written statement, the defendant is not appearing? Defendant may not appear, even then the court will not grant, because court will go to the plaintiff and find out whether the plaintiff as framed is maintainable in law. Here the suit as framed is what? Is that there is an order passed by the ADC which is coming in the way of declaration of a title in favor of you by the court. Unless that order is set aside, the question of giving the relief of declaration of title will not come. Because it is, and it is very clear from the reading of the bare reading of the plaint itself. If we read the plaint, we find that this without the implement of the authority which passed the order and the authority, my lord, or the state, because authority will be an agency of the state. In such cases, normally, my lord, state government is required and state government is made a party, and ADC or the DC, whoever passes the order, comes as a second defendant. First is the state. Now, without state, without the authority which passes the order, you file the suit and you want a decree that this order should be set aside. This order was passed by the ADC. So ADC is a necessary party, but for that, no evidence is required. That is what I'm saying, my lord. In my humble submission, there may be a case where defendant should clearly state as to why the suit is bad for necessary party. And in a family dispute, some of the family members, we can say that the suit is bad for non-generous of one of the family members. In that case, defendant must come forward and say that how the family member is a necessary party, and thereafter the court will decide whether the suit is bad for non-generous of that particular necessary party. But here, going by the prayer made in the plaint, the whole frame of the suit is such that they are asking for declaration of title, and they know, they are very much clear in the plaint that this is the order which is coming in the way of their ownership over the property. And my lord, this is a case where the defendant's case is that they were earlier tenant, they were occupancy tenant, and thereafter, my lord, they have made an application under section 23. Under section 23 reads like this. 23 says acquisition of ownership rights. Before that, I take your lordship to the occupancy and non-occupancy tenant. Section 5. Lordship may state
Section 23.
Page, my lord, page 255, your lordship will find the section 23 of this 1971 Act, Assam Temporary Settled Areas, Tenancy Act 1971. Page 255 in that book, possibly, my lord.
No, it is section 23 is in page number 260.
My lord, I'm taking first your lordship to section 5 of the Act at page 255.
5.
My lord. To show that what is the definition of occupancy tenant,
Yes,
how it
yes.
is acquired. Section 5, acquisition of occupancy rights. A person who for a period of not less than 3 years has continuously held land as a tenant shall have a right of occupancy in that land. The period of 3 years may wholly or partly, because this we can skip. Now, next page, I'm sorry, my lord. At page 260, lordship will find section 23. Page 260. Acquisition of ownership rights and intermediary rights by tenants. Any occupancy tenant personally cultivating the land of his tenancy, desirous of acquiring the ownership rights of his landlord, may at any time make an application in writing to the Deputy Commissioner, and on such application being made, and compensation as provided in section 25 is determined and paid by the occupancy tenant, the Deputy Commissioner shall declare the said occupancy tenant to have acquired the ownership rights free from all encumbrances. Now, this order was passed on 9/5/2003 by the ADC.
At page number,
My lord,
have you enclosed the order?
Order, my lord, it has been exhibited, it is possibly exhibit 3.
Part of the memo of appeal?
Yes, ma'am. This your, it has been. And this your lordship will find. Yes, it is in the part, it's not part of the memo of appeal, it is in the LCR manner.
Okay.
Exhibit. This is exhibit 3 minor entitled suit number 1 of 2004.
Yes, so take it. So, can you find it out from the
My lord,
LCR?
my lord, yes.
So after 5 minutes, we will resume.
We'll find it. Lordship is good, manner is 9. And the relevant part is the last part 1 page 66 what we will find the bottom paragraph. হে হে সকলো দিক বিবেচনা কৰি বজালী চক্ৰৰ অন্তৰ্গত সৰিয়হ মৌজাত ৰায়পুৰ গাঁৱৰ 218 নম্বৰ পট্টাভুক্ত 905 আৰু 908 নম্বৰ দাগৰ সমুদায় জমি ইমান লেচাত আবেদনকাৰী শ্ৰী লাবণ্য কুমাৰ দাস পিতা দেৱকুণেশ্বৰ চাংকি ৰায়পুৰৰ পট্টাদাৰৰ সকলৰ স্থলত মালিকী সত্ত্ব মঞ্জুৰ কৰা হ'ল. This is the relevant part. And this is in terms of section 23. And just this paragraph above that says that they will have to pay compensation in terms of section 24. So this is the document. Section 20. And
Yes.
only one thing, the substantial question of law was also framed in their absence, and today I am told that they are not fully prepared. But should we take it up some other day, because otherwise.
Okay. Only on this point.
Initially on this point, manner, and if necessary, the other points I will have to argue, manner. It's not that I will not have to argue the other points also.
Okay. Heard Mr. D. Mazumdar, learned senior counsel, assisted by Mr. Hor, learned counsel for the appellant, and Mr. Deka, learned counsel for the respondent, and Mr. Bora. For respondent number?
345.
345.
17th, not in the 17th of September.
17th of
It's a
September.
Tuesday, my hearing.
So list the matter on 17th for further hearing.
If you want.
Item 22.
Please, Your Honor. Actually, the counsel for the appellant, he is suffering from viral fever, so he couldn't come today. So you be Sharma.
Next week, my lord.
Next week.
Next week.
Next week. Miss, your good name?
K Sharma,
Miss K. Sharma, Learned Counsel, appearing on behalf of Mr.
UB Sharma.
Learned Counsel for the appellant, with concern from the other side, press for listing the matter. Okay. Data that is for 15 matter. Second week of September.
My lord, not 12 and 13, my lord. I am out of
Suggested that then?
my lord.
Suggested that?
Within first week, it is possible, my lord. Not then.
First week may not be possible.
Then, my lord, after 14. On 24th September. Yes.
24th.
Item 23.
Same matter?
23.
Yes, Lordship, the same.
Same order.
For the appellant as well.
Same order. No. But who is for the respondent?
We're for the appellant, Mr. UB Sharma.
Heard Miss Winslow, Learned Counsel for the appellant, none of this for the respondent on call. List the matter on same day or different date?
They will. I think, will you please give a date for like 2 weeks?
Pardon?
2 weeks.
26
Date
September.
of 2 weeks.
26 September. Item 24.
Obliged.
Wait, please, Your Lordship. This is an appeal by the railways against the judgment and decree dated 27/4/2015 passed by the trial court, my lord, directing, my lord, allowing the prayer of the plaintiff therein for recovery of the contractual dues from the railways, my lord. My lord, in the suit, my lord, the claim of the plaintiff was for recovery of an amount of 51 lakhs plus interest. And whereas, my lord, prior to that, he had filed a writ petition before this honorable court with regard to the same claim, my lord, claiming an amount of 18 lakhs. And in the notices under section 80 also, the claim amount was rupees 18 lakhs only. Now, evidence were adduced by the plaintiff side, my lord, in the suit. Railway filed their written statement denying the claim and stating that the amount which was receivable by them was set off unilaterally by the railways because of the fact that some dues were recoverable from the plaintiff side. Now, that order is not under challenge, was not under challenge before the trial court, and railway further, my lord, did not adduce any evidence. My lord, although they had filed a written statement, my lord, I should admit the railway did not adduce evidence substantiating their claim, my lord. Now, my case is, my lord, the plaintiff has claimed something, my lord. Now, although there was no evidence on the part of the railways, the plaintiff has to prove his own case. That is a subtle position of law, my lord. Just a bold statement would not do the thing, my lord. Now, here, what I find, my lord, from the evidence, from the documents that were placed before the trial court, my lord, the claim, the principal amount is only 18 lakhs, my lord. But the trial court gave the decree for an amount of 51 lakhs plus interest. Future interest pendant line, that is basically our case, my lord. But the thing is, my lord, I've gone through the LCR court records, my lord. The evidence part of the records is not available, my lord. Probably that would be required. I have searched it thrice, my lord, that those exhibits, my lord, evidence, my lord, is not there in the LCR.
In the LCR?
Only they have not sent it. I could not trace it out, my lord, in the LCR.
LCR to
The C file is not there.
I see.
That B
Forwarding
file
the-
contains the documents, but not the exhibits. Basically, it's a case of granting interest on interest, my lord. That is not permissible. Even assuming something is due from the railways, my lord, that principle has to be ascertained first, then the interest amount to come, my lord.
C file.
If lordship just peruses one document, page number 440 of the LCR, that is one document, probably that was exhibited. His claim is absolutely clear. The principal amount is 18 lakhs something. That was probably exhibited also, but that is the very basis of his claim. So
Page number
440. That is in original itself.
Hmm. 440.
440.
Yes.
That's basically the claim. There were 9 contracts. On the right hand column, my lord, the tender value is depicted. The second column reflects the bill value. Third payment, the third column reflects the amount received against that particular contract, and the balance amount is the last column. So sum total of all the 9 contracts is 18 lakh something rupees, my lord. That is basically the principal amount. Even assuming, my lord, something is payable, that would be the principal amount, and on that amount, the interest can be calculated, my lord. That is what section 34 of the CPC mandates. Now, from where this 51 lakhs came, my lord, that evidence is, the plaintiff side could not prove that fact. That is my case. So this finding that the principal amount is 51 lakhs is perverse.
So without the documents, can we hear the matter?
That's the thing, my lord.
Yes, Mr. Ravi.
Say, Lordship, the case is not that like that as is presented. The case is plaintiff is very clear, and we have examined also myself as a plaintiff, and there is evidence is clear. So all the documents are there. The only thing is that the defendant's case is that only someone, one of the defendant without any authority, his own individual capacity is having WS. The fact is remains that the real point is that none of them appeared as witness in the box, in the witness box. That is why there is a Supreme Court ruling that when the evidence, WS is there, if none appears in the witness box, then the inference is that they have no case. There is the trial court on relying on the Supreme Court's judgment that what so as far as the defendant's case is concerned, they have totally failed. And other things is so far as amount is concerned, 18,000 and 21,000, it is only case of interest, but the principal amount is there. And we have submitted all the documents. And the plaintiff's case is there. Claiming of the principal one. That is
No, whether all the documents are available in the lower court record.
In my record, evidence that part of the evidence is only the evidence of the plaintiff. And that is, we have seen it today, we have not here. Not here.
It's not there. That is the thing.
But in the record, I have not seen. It might be
But
there. because we have
you
already
check it, you check the record.
Yes.
If it is available, we will post the case for hearing. Like that. You check it.
That is the only limited thing question out here.
We'll take it up at 2 o'clock then. In the meantime, you both of you check the record.
Check it thrice, my lord. Lay my hands on.
Boarding report to ever silo or some tate equally.
Evidence 9.
Item number 30.
There.
May please, Your Lordship. Your Lordship, to be fair to the court and so that we don't know, this is a case where it has to be remanded back to trial court for deciding afresh, Your Lordship.
Hmm.
What has happened, Your Lordship? In this matter, I was the defendant, Your Lordship. My deposition had not been considered. My exhibit had not been considered. The judgment, it has come that there is no exhibit, nothing at all. If Your Lordship will see the play, Your Lordship, here an interesting in the judgment, Your Lordship, the trial court has granted decree to the plaintiff as well as defendant 1 to 6 without a counterclaim also. Whereas, Your Lordship, defendant 1 and 2 filed a WS stating that suit is not maintainable and they didn't contest the appeal. Defendant 4 to 6 has preferred the appeal, stating that judgment is wrong. Basically, what has happened, Your Lordship, the land in questions belongs to appellant number 4, defendant number 7 in the suit. It's a society Kepanijal Undan Samiti, and 4 persons, 4 brothers, they have purchased the land on behalf of the society, Your Lordship. Now, what has happened, Your Lordship? The suit has been filed by 2 streams. One of the brother's son, they are as plaintiff, and another brother's son and daughters, one is a plaintiff, another defendant number 1. The other one person, he didn't contest, his children didn't contest. The 4th person, sons are the defendant. They said this suit land doesn't belong to us. It belongs to the society, Your Lordship. And Your Lordship will see, it's a known fact that a suit cannot be decreed on the basis of, if Your Lordship see the reliefs in the plaintiff, that I've taken to the reliefs, Your Lordship, page
number.
I just take Your Lordship, keep it. Plaintiff that, Your Lordship. Plaintiff that it's that.
Lordship, I can give a list of dates. Lordship will find everything from the list of dates from the page.
Your Lordship, page 45, see the decree. Page 45, Your Lordship. Page 45. Actually, what has happened? They have basically filed a suit for recovery of rent, not for rent, and declaration of title without possession, Your Lordship. Because they admitted there is no possession of the land here. Your Lordship, specifically, Your Lordship is aware that a suit without possession, you cannot have a declaration, Your Lordship. Declaration and injunction, Your Lordship. In the plaint also, they have not stated that they are in possession of suit land. Whereas in cross, PW1 has admitted that possession is with the society since 1957 also. So if Your Lordship will take a page 46, the prayers are there. In the, we have annexed all the documents here, so they don't be problem. Your Lordship, see.
Yes, got it.
For a declaration that plaintiff has got joint right, title and interest, along with defendant of 1 to 6 the schedule will have. This is a peculiar thing. Further declaration, plaintiff has got right to collect the rent. This is the main rent from the traders of so-and-so, law firm Sariali Weekly and Daily Market, organize and hand over schedule B land to the extent of share of the plaintiff, that is the extent of 75 and respect of so-and-so. Then, if Your Lordship see decree in favor of plaintiff number 1 and 2 for realizing 18,000 for the defendant jointly, that is also rent, 1/4 share.
No, 18 lakhs, not 1,000.
Yeah, lakhs, sorry, I'm sorry. Sorry. Also in favor of plaintiff for realization of rupees 3,37,000 and so. Defendant share collected rent source. A decree, now E is very important. Permanently restraining the defendants. That means defendant 1 to 6 also comes here. Their main agent from distributing plaintiff collecting the rent from the traders of local Sariali Bazaar and Daily Market organized so and so. Schedule will land to the extent of share to the extent of 75,000 eventually in respect of plaintiff number 1 and rupees 18,700 in respect of plaintiff number for appointed receiver. Your Lordship will see here the prayers are very defective prayers. Your Lordship, how can you have a decree in favor of defendants also? And trial court, if Your Lordship will say trial court, last court. Trial court, Your Lordship will see. That decree of the
If your lordship takes page 26 of the trial court, I'll come later on your lordship. Page 26 order.
Yes, yes.
The suit is decreed on contest with cause. The right, title, and interest of the plaintiff in respect of suit land described in Schedule B land is hereby declared jointly along with defender 1 to 6, and the plaintiffs are also entitled to collect rent from the traders of so and so to the extent of the share there is so and so. Here your lordship will see decree has been given to defender 1 to 6 also.
Hmm.
Here your lordship defender 4 to 6 are the appellants here also, along with the others. There are there are total 11 appellants. 11 appellants, your lordship, and 4. Yeah, sorry, 8 appellants, your lordship, and out of that, 1, 2, 3 defender the appellant number 1, 2, 3 are defender number 4, 5, and 6, your lordship. That is at page 2, if your lordship will see. Page 2. Appellant number 3 is defender number 4. Appellant number 2 is defender number 5. Appellant number 1 is defender number 6. And defender number 4 is the society in the whose the land was purchased. Now, their case is that they have purchased not on behalf of the society, your lordship. The original sale has not been exhibited also, only certificate copy has been given, your lordship. So, your lordship, if your lordship will see this, then if your lordship will see next page of 27, your lordship, documented in the trial court judgment, if your lordship will see. Plaintiff witness is a PW1 Pulin Mikir and PW Vijay Tamam. Your lordship here, if your lordship see defendant witness GW Soven Mikir, he is not a witness or he is the witness of the plaintiff. But in that, what has happened? The trial court has recorded 2 DW1. This is all a DW1. Our witnesses are DW. We have also given 3 witnesses. DW. There are 2 DW1, your lordship. Here, if you are Soben Mikir, he has given deposition on behalf of the plaintiff. None of her deposition has been considered, your lordship. And if your lordship say document exhibited by defendant is nil, that is also incorrect, your lordship. We have exhibited more than I think 20 documents and marked as exhibits. Exhibit it starts from exhibit co and it goes to this thing, your lordship. That you have stated, your lordship. Yes. That is that those documents are exhibited here. You also have annexed the documents also. Those are all exhibits. It starts from page 186 here, your lordship. See. Page 186 is exhibit 4, your lordship will see. This is one document. This is a sale deed, your lordship. What has happened, your lordship? Here, in the sale deed, what happened, your lordship? The original sale deed, the name said on behalf has become slightly down below that. It is they are taking advantage. They took advantage of that, your lordship. The original sale deed is there. Exhibit at page 355, your lordship see. Yes. Page 188, sorry. Exhibit the Assamese thing is there. If you say Raijor Gaurav Likhito, so and so. So it is on behalf of this thing, your lordship. What this should have been above here. It has come with a seller also, by a seller also. Seller is Hiren Ram Bhugan, Viren Rapukar. They are the seller actually. This line should have been above here. Only that they are taking advantage of that. And in fact, they have admitted the deposition also in the cross-examination that this purchase, their land has been purchased on behalf of the society, your lordship. If your lordship will see, I'll just take that your lordship, the other documents are there. The other documents are here, all annexed, your lordship. And if your lordship see exhibit Kho, page 201. Here, the patta has been given in name of patta has been given in name of the appellant number 4, your lordship, the society. Page, this is a society, page 201, just testing your document. 4% name of the all this they have purchased on behalf of Rajwa Srivi. Then the Assamese person is next page, your lordship, the original one, 402, the 202, sorry. Then if your lordship will see page 203, this is the patta, periodic patta, in name of appellant number 4, page 203, if your lordship will see. This patta has not been challenged, your lordship. If your lordship turn to page 205, it is given that the dark numbers are given. These have not been challenged, the suit, your lordship. Then, if your lordship see the plaint also, in the plaint also, they have not claimed they are in possession of suit land. I'll show it from the plaint also, if your lordship see the plaint. Your lordship, there are 11 exhibits marked, but it is more than 20, your lordship. Like A1, subclause 1, 2, 3, the receipts are there. So total comes to around 20 documents, I think. That has been exhibit, marked exhibit. This has not been considered. Then if your lordship will see, no, now your lordship will see, let me go take your lordship the plaint, your lordship. Plaint, if your lordship see the plaint, plaint starts at page 28, your lordship. I am taking the relevant page, your lordship. Your lordship, see page 30 of the plaint.
Yes.
Suit for declaration of right, title, in interest of the plaintiff over the suit described in Schedule B. There are two, one Schedule L is also there. And also declaration of the right along with the defendant to collect rent from the traders of so-and-so, organized so-and-so at rupees 21 lakhs permanent injunction suit values for the purpose of the maximum court fee so-and-so. The suit comes also to your lordship. If your lordship will see, sorry, I'm sorry. I have just referred to the plaint started page 33. I'm sorry, your lordship. I just referred to now. If your lordship will see, if your lordship, it is page 35. I'm sorry, page 35. I referred. That was the judgment decree. So for declaration of right, title, interest of the plaintiff over the suit land, describing Schedule B, and also declaration of the right along with defendants to collect rent of the traders, organized suit to the extent of the share, if it's 20 permanent election for the maximum, so your lordship. If your lordship will see here, they have, if your lordship see the said land has been, if your lordship down below, yes, then the said land fully described Schedule A below. Here you have to refer to suit Schedule A land. There is no relief claim in reference to Schedule A land. No relief. It's only Schedule B, your lordship. Then I take your lordship. Here, the lordship see. Because the matter went for the Board of Revenue settlement, it was the Board of Revenue has made a declaration that the land belongs to the appellant number 4, your lordship. Board of Revenue also, they went to the Board of Revenue also, and first they succeeded and we went appeal to the Board of Revenue. Board of Revenue has given an order verdict in their favor, stating that the appellant number society is the owner, and they have interpreted sale deed also. That sale deed, that portion, that rise or hoy, that going above, that thing has been interpreted by the listing. That is at Board of Revenue page. Just I'll show that page number, 11 page number. If your lordship goes to page 239, page 239, that Board of Revenue's order, your lordship. Para 4, your lordship.
Yes.
Peruse the application dated 20 submitted by the appellant. In this petition, it stated that the appellant, see Boloram Mikir, along with Sutiram Mikir, Kanti Mikir, and John Mikir, as Rais Goria, representing the general public of the village of Kapada, purchased a plot of land measuring 9 bigha 4 katas and half, tag number Patta, number village Kepanijal under the Beltola Moja, and from Hiren Ram Fukon and Biren Ram Fukon by registered sale deed number so and so. Since the date of purchase, the rise of Kepanipal are possessing the same, having right title interest upon the land. At present, the aforesaid dark number so and so converted. So here your lordship is possessing, Board of Revenue has had possession to be there. And I will take your lordship to their deposition, PW1, they deposit PW1. They have categorically admitted they are not in possession also, your lordship. So if your lordship page 67, if your lordship turn, that is the cross of PW1. Page 67, your lordship will see. This is the deposition cross starts from, I just give the page. Cross starts from page 61, Your Lordship. PW1, their witness.
Yes.
If Your Lordship will see, page 67, I've come to page 67, Your Lordship. In support of Lokra Sarira, I have not submitted any document. Suit land document. I am not a man of the rise. That means the disputed land is under position Khepadela as they are running the shop. Here they have admitted, Your Lordship, they are not in possession of suit land, Your Lordship. PW1 cross.
Which part you were reading?
Your Lordship, page 67, if Your Lordship see.
Yes.
Right from in support of Lokra, I have not submitted any document. They have not submitted claiming the right of the thing. I am not a man of rights. That means he is not a part of. He said then the disputed land is under possession of Khepanijal rights. That is appellant number 4, and they are running the shop there. I have not submitted anything regarding my claim for one and mentioned paragraph 2 of affidavit. At present, it will be land dark number so and so. There so and so. There is no mention of boundary exhibit which will be in the court. The boundary is also not. They have admitted. Then I take Your Lordship to page 70. Page 70. 73 also, that is again further cross again, page 73, Your Lordship will see. Page 73, if Your Lordship will see, that is a further cross again PW1. In this aforesaid, they have filed a writ petition. Balaram Mikir and President of Khepanijal have filed objection before the Honorable High Court. Since the disputed land was under possession of Khepanijal governors by virtue of purchase prior to 2005, that is on 30th. So they have admitted here also that possession was not in possession, was always with appellant number 4, and still now the possession is there. If Your Lordship, down below, if you say, at the time of filing, WP number so and so Balaram was alive, and Balaram have filed objection to aforesaid. Since Balaram Sarkar, John Miki, Kanti Miki has purchased the disputed in Nigeria on behalf of Rice. Then next page, Your Lordship, 74, if Your Lordship see. Waris of Kanti Miki, Balaram Miki, Sutime, except plaintiff have not filed any case claiming right, title, and possession as any civil court, Your Lordship. Then if Your Lordship say if there's a Pacha Pata, I don't know here, so and so, Your Lordship, then if Your Lordship see page 75. The area of land of Doinik Bazar, Khepanijal is about 1 biga 3 katha, area and weekly bazar 8 katha 1 katha, Your Lordship. The total was 9 bigas. So here Your Lordship will see, he has said he doesn't know about the boundary also. He is deposing here, sir, and he doesn't know about the boundary. If Your Lordship see the boundaries are different, Your Lordship. He said, I have not submitted any paper relating to aforesaid boundary. I myself make the boundary by knowledge. I have heard orally about the disputed land from my father. My father has expired 11 years. So question is very clear. He doesn't know about the position. He doesn't know the boundary also, schedule also, and he's claiming it. Then Your Lordship will. Then if Your Lordship will see, I have shown that exhibits are there. Your Lordship, it starts from page 186. It goes to the end. I'm not taking Your Lordship. Then these are all my exhibits. It goes to this thing, Your Lordship. Then Your Lordship will see. So position is not there. Your Lordship, when position is not there, they have admitted position is not there. So there can be declaration of title under section 34 specifically. Your Lordship knows I do not trouble at that. Section 34 of specifically, without position, you cannot claim right title and interest in the property. And Your Lordship. And Your Lordship, there is judgment of the apex court on that also, Your Lordship. It's AR 1972 Supreme Court 2685, Your Lordship.
AIR
1972 Supreme Court 2885. 2685. So 2685. I'm sorry, 2685. And para 4 years. Para 4 of the judgment I said. we are agreement of the High Court so as found in the Partial Court gathered is in possession of some of the suit land. The plaintiff have not sought possession of the property. They are merely claiming declaration of title and they are the owners of the suit project. And the suit is not maintained in the circumstance. So here the judgment has Apex Court has said that if you don't have possession, you cannot claim title over the suit property or any relief, your lordship. Then here there is a judgment of this honorable court also. 2012 1 GLT, page 382, your lordship. Here, if your lordship will see, it is at page paragraph 14, 15.
Page number?
Your lordship, page is 382, your lordship.
382.
This was at that time by Agartala. It was given at Agartala bench, but it was the combined high court, your lordship. 2012, your lordship. Your lordship will see paragraph 14 of the paragraph. I read the for a convenience of paragraph 14. In a civil suit, in the absence of the relief sought for the plaintiff, the relief cannot be granted by the court by making out a new case inasmuch the plaintiff has not proved his case pleaded the plaintiff so and so. It is fairly well settled that a party in a civil court, this paragraph 15, your lordship, cannot be allowed to travel beyond what has been pleaded in the respective pleading and has to make out a new case wholly inconsistent. The only pleaded case proved is so and so is the other. It is equally well settled that the decision of the civil court cannot be based on a ground outside the pleadings of the party. It is necessary. It is a case of the plea that has to be proved. Therefore, a finding reached without proper pleading is necessary. So and so. In view of the settled position of the discussed, the court is of the considered view that a submission of landed council appearing so and so relief could be granted. So for the foregoing, the first step, substantial question of formulated in the present second is answered in favor of respondent. In the court hall, the presence of that is not maintainable in the present form, and the same is dismissed. That same thing is, as the suit has to be decided. So you are the same thing without possession, you cannot get a declaration of title. And another judgment, your lordship of Guwahati High Court, this honorable court, AIR 2001, Guwahati 181, your lordship.
AIR 2001.
Guwahati 181 is for Imphal bench. It was given in Imphal bench, your lordship.
Okay.
Your lordship, page, your lordship, para 16 of the judgment. Your burden of proof, on whom the burden of proof lies can be ascertained by taking note of the fact as to which parties will succeed if no evidence is given on the either side. The burden rests on the party who would fail if no evidence is at all adduced. The burden of establishing the case rests upon the party who essentially asserts positively the issue raised in the burden. The burden remains unchanged and never shift. On the other hand, circumstance clearly in Section 1 Evidence Act. The aforesaid rule pertains to burden of proof as a matter of law and pleading. The other as a burden of proof is the burden of admitting evidence. The burden of proof in this respect may shift throughout the trial. The distinction between the burden of proof and a matter of law pleading is that existing evidence is a matter of prime importance. As alluded, the plaintiff came for a declaration of the title, and therefore it was a plaintiff to establish their title effectively. When the plaintiff is where the plaintiff for a declaration or decree, she must prove that her title, and it cannot take advantage of the weakness of the defendant. More so and so, your lordship. So here it is also clear that you have to prove your case. Possession of in the plaint also, I've shown they are not claiming that the plaintiffs are in possession of suit land for seeking a declaration. That has to be there. There's not a pleadings are there. Your lordship, there's another judgment of the Apex Court, your lordship. 1998, 9 SCC 719, your lordship. Is that sort of para 4, your lordship. It, however, appears that although High Court indicated in the impugned judgment that the defendant claim or easementary right and also the claim of title by adverse possession would not be accepted, such weakness of the defendant titles of the suit property cannot establish the plaintiff's title. The High Court has failed to consider specific findings made by the lower court that the plaintiff has failed to establish the plaintiff's title. It may be noted that the plaintiff was not entitled to get a declaration of title if such title would not be established by the plaintiff by leading evidence, convincing evidence. The lower appellate court has considered the evidence in detail by giving cogent reason, has come to the finding that the plaintiff has failed to establish a title to the work. Such finding was not reversed by the High Court by indicating any reason of such reversal, but indicating the weakness of defendant title of the plaintiff suit was declared. Even if we assume that property in question was bequeathed by so and so by executing will, the title to the suit property cannot be declared in favor of unless the title for executor of the will is fully asserted. In the aforesaid fact, the impugned judge of High Court cannot sustain the same issue, etc. So Your Lordship has also said, even if there is a will or something, you have to establish by probate author that it is with you for declaration of title. So Your Lordship, this aspect. Yeah, I'm thinking. Now, Your Lordship, I mean, first I'll take the WS of the suit, Your Lordship. That is very important. That things big clearer also. I just. Page 126, Your Lordship, is the WS of defender 1 and 2, Your Lordship. If Your Lordship say the degree was given in favor of them also, Your Lordship. Defender 1 and 2 has filed only WS, they didn't contest the suit at all. They didn't come for evidence, nothing. Only the WS has filed. Here, if Your Lordship will see that the suit filed by the plaintiff is not maintainable in law as well in facts, and the case as such the same is liable to be dismissed. The suit is not properly valued so and so. The suit is bad for non-judicial and liable to be dismissed. Your Lordship, then next page, if Your Lordship will see, para 7, Your Lordship. They have said it is further submitted that general people of the area cannot claim the right over the suit land and no name has been muted as Raj Gai in respect of disputed land. The title of suit land has not at all been decided. And mayor position, the title and here also he admits the title and position has not been decided according to them. So and so an absolute title and sin Raj Gai, which alleged to have been represented by Khepanjali government who had no locus to present the suit land on behalf of the Raj. Your Lordship, this WS was filed and the trial court has relied on the WS without any evidence to give a judgment in the favor. They said if they have also stated that. I'll show that. That's why I'm reading this thing.
No evidence, it is.
No evidence. They didn't appear, just filed the WS, they didn't appear because there was no evidence, nothing. Then if Your Lordship, this I'll show it from the judgment later on, Your Lordship. Then Your Lordship will see defendant number 3, he filed a WS also. Defendant number 3. He was shown as DW1, but he should have been shown as PWC, Your Lordship.
Page number?
Page number 131 starts, Your Lordship. Excellent. He just said that, Your Lordship, he just supported the case of this defendant, and he's not a co-player. He's not been transferred to the defendant plaintiff also, Your Lordship. Your Lordship, see, that a 4 bigger one that have said, Your Lordship, they said that suit land was purchased by father of defendant, namely so and so, by registered sale so and so. All of them are equal share total measuring units. The land in the names of the record right also collected equal so and so. Your Lordship, he has filed this thing and he said with regard to statement made next page, para 4, answer your begs to submit a recital made in a particular sale deed does not discern any meaningful extent what rise girl. So this he has raised the objection on this only, Your Lordship. And with Board of Revenue has heard, and if Your Lordship see the documents also, that also shows that is on behalf of the Raj Gai. Then Your Lordship, that defendant number 4 to 6 has filed a WS along with the other appellants, along with different. If Your Lordship will see, it starts on page 137, Your Lordship. This is a WS filed by us, Your Lordship. Filed with the appellants here.
Page number?
Page number 137, Your Lordship.
Yes.
130. If Your Lordship will see para 7, that is a statement when paragraph there. The land measuring 9B of 4 dark number 1 to KP Patta so and the Khepanjali as purchased by the Boloram Suti Mikir and so as Raj Gai on behalf of Khepanjali by registered deed of the sale bearing sale deed number so and so. and original Pata number, and from the original Pata, Biren Ram Fukan, Hiren Ram Fukan, both were sons of Sri Navin Ram Fukan of Boroluk since the date of purchase of the rise. Since the date of purchase, the rise of Keba possessing the same without any reserve for any girl. So position, we have categorized the position with us. And they have also admitted the position is us. Answering Japan further begs to state the suit land belongs to Rise of Kepanipal since the same was purchased as Rise Goria. That is on behalf of Rise of Kepanipal by Boloram Mikir, Sutti Mikir, Kanti Mikir, and John Mikir. And the suit land is not a personal property of Boloram Mikir, that is of the father of defender 4 and 6, 4 to 6. And the father of defender 1 and the father of defender 2 and father of plaintiffs. Number 7, the suit land is absolute property of the Rise of Kepanipal and Rise of Capital have constituted a committee, namely Capital John Under Committee, for the proper maintenance movement and property. Rise, including so and so. So here, this society is a registered society also. I have submitted document of registration is also there. I have the document society registration. Registration of document concerning it's there. Registration document is also there. Yes, page 223, your lordship. That's the exhibit Ritio saw. That's also exhibited. Page 223, your lordship.
Got it.
220. Now, if your lordship will see, for this land, we have been paying the taxes, everything by us, by the appellant number 4, with different that those documents are also exhibited. Because those documents starts from. It starts from. Your lordship will see. Excellent. Your lordship, page 206, I have already shown your lordship. That is a periodic list, Katta list, it made of Kepanijal Downs Committee. This is there. Then this, then your lordship, land revenue is page 208, your lordship will see. 208, 209, 209, Assam is one, your lordship. 208, 209, then 210, all in capacity, 211, 212, 213, your lordship, it goes. All these documents are in this page, 217. Then GMC also we have paid, that is a 218. 219 is GMC tax, your lordship, 220, then 221. These are all exhibited, your lordship. Till your lordship, yeah, receipts are from 208 to 222. Which all in the name of defendant appellant number 4, your lordship. That they are they have not shown that they have paid any tax to the, if they are owner, they are not shown any tax, nothing out there. These documents are not at all considered by the trial court, your lordship. That's why your lordship will see he has no documents filed by defendant. Your lordship, that page, that judgment, your lordship, see. Your lordship see page 27, your lordship. Page. Page 27, if your lordship will see. I'll continue after lunch.
Yes.
Documents exhibited by defendant Nil, page 27.
Nil.
We have exhibited so
But
many.
whether those documents are marked?
Yes, marked, exhibit, they are all marked. There are record case. Here are exhibit.
So, how many documents you have exhibited?
Your lordship, it is, I think it, actually number is 11, but if there are subclause 1, 2, 3, what it comes to around 20 documents, your lordship. Here, I just give your lordship. I just give you the hotel. How many documents? X. 1, 2, and receipts are all subclause. So it comes around to 18 or 20 documents. They are all exhibited, your lordship. In serial number, it goes to 11, but there are subclause 1, subclause 2, that way also the receipts are marked that way. So in total, I think 18 or 20 documents has been exhibited. I have to check up that. Either 18 or 20, Your Lordship. We have exhibited documents that have not been considered. We have given a exam. We have been examined also. Our witness has not been considered here. We have examined our deposition also on record. Your Lordship. We have put listing on record or deposition also.
Page number?
Deposition, I just our deposition is there. Your Lordship. Page 158 as a 155. Yes. Exactly.
You have examined only one witness.
No, we have examined three. No? DW1 is there. There are two.
But the judgment indicates that only one witness is
No,
examined.
that's not my witness also.
Soven
So that is Soven Mikir is their witness. That is different. That's why I read it that way. They have made, there are two DW1. This is also DW1, Your Lordship.
Not our witness. You would see our witness. Our witness.
Not DW, he's not our witness. He has been wrongly marked because he has given it in favor of you. We have not examined him. We have not examined him, Your Lordship. That Soben Mikir has not been examined by us. Here, if you say here also page 1 with DW1 is a Nalin Mikir.
He's a defendant, that is why.
Defendant, but question is you cannot make a part 2 DW1. He is not our witness. I say he is not our witness. He wrongly put DW1. He is not my witness at all. If you look at page 151, DW1 is Nalin Mikir here.
151.
158, Your Lordship. Nalin Mikir is DW1, Your Lordship. Nalin Mikir is DW1, Your Lordship. DW1, Your Lordship. There is Soben Mikir. It said that DW1 is Nalin Mikir.
Lordship, whole cases has been filed like this, Lordship. One here is a plain, here WS, thereafter evidence, again WS. Whole case has been structured like this. Everything took place, that everything has been anomaly. Lordship will find the evidence, thereafter plain, again evidence, thereafter WS. These are the projection in this particular case. Lordship will kindly see what have stated. I will not argue now, Lordship, because it is 1 o'clock. They are saying that they have a registered society. Lordship can see the registered document, page 223. That is a registered document of 2008. The land is purchased in the year 1956. This is a society of 2008. They are claiming they have purchased the land in 1956.
The society was registered at that time.
Society registered in 2008.
Yes.
The document itself says they have purchased it, and they are claiming that they have purchased the land in 1956.
Yes, on behalf of rights. That's a 4%.
Without being in society,
there was no register. That's the name of the four
The
villagers.
question is, can the trial court grant a right title and position in favor of the defendant without any counterclaim?
Defendant, we are claiming right title and interest along with defendant number 1, 2, and 3.
1 to 6.
Wait, 1 to 5.
To 6.
We are the plaintiff
See the
along
prayer,
with the defendant number 1 to 5.
See the prayer, please. See the prayer. Your prayer
1
is
to
there.
5.
It is defendant number 1.
That is already settled.
Defendant 1 to 6.
We can claim
Page
joint
46.
position, joint right
Page
title and
46.
interest with defendant.
Page 46, Your Lordship. 1 to 6. Without a counterclaim, how could they should have made plaintiff then?
Sale it 189. Lordship can see sale it 189.
Oh, yeah, I've not,
Sale it 189. Lordship can see
I have
the
not
original
got
sale.
to say that. I'll go to those things. I started only.
My lord, I may submitted only one thing. He has prayed for right to the interest along with the defendant. There is no application under other one ruling authorizing the plaintiff.
How can they represent the defendant?
Without prayer, how they can?
How can they represent as the
Is there any provision?
I will place the judgment on these points whether I can claim right title and interest with the defendants along with the defendants.
We have contested the same.
Supreme Court has already settled the matter that right title can be declared along with the defendant also. My right can be declared along with defendant number 1 to 5.
But they are opposing.
They have filed
maintainable.
WS.
They have said suit is not maintainable.
They have filed WS stating, admitting that land has been purchased by their parents for their own right, not in their favor of rights corridor.
They have not stated.
My lord.
Okay, Mr. Solore, do you have any other point?
I have other.
My lord,
after lunch.
just one. My lord.
After
After recess.
After recess.
My God, just 1 minute. He has prayed for right to the interest along with the defendant. In para E, he has prayed for injunction against the defendant. On the other hand, he has prayed for right to the interest.
Injunction against that I showed it also.
Injunction.
How can he claim injunction against the defendants also? 1 to 6.
1 to 6.
They are also included. They are not excluding 1 to 6, they have not said.
Okay, we will continue then at 2 p.m.
Yes, okay.
Small prayer matter.
As agreed by learned advocates of both sides, let's list the matter on suggestion that
Today is 27.
On 19th. 19th?
Nick,
On 19th. 19th. 19th.
19th September.
19th September.
Interim order may be extended.
Pardon?
Interim order may be extended.
Okay, till then interim order pass early self continue.
Much obliged.
Yeah, yes, Mr. Surri.
Yeah.
Yes. Dubey?
Item 39, Lord, Central Government Council could not be located, Lord. That was I was informed by my friend, Mr. Das.
When to be listed?
If we take in
Mr. Das is not in the court, he'll be coming soon, your right? If your lordship may fix either at the end of the list or any other day.
Any other date?
As per the convention, what is that? I am not the, I don't have the local committee case, I am just, since he just informed me that he is not in the court, he'll be just coming in your honor.
tomorrow, if possible, my Lord, can take.
Tomorrow, could be possible. Better.
But
Okay,
otherwise,
tomorrow. That's agreed by learned advocates of both sides. This is the list the matter tomorrow. Yes.
Your Lordship, to buttress the point which my learned has raised, I am referring to provision of CPC, that will clarify everything, Your Lordship.
Provision?
Provision of CPC, Your Lordship, I
Ah.
just, that will clean the whole issue, Your Lordship. Your Lordship, order 1, rule 1 first. Order on rule 1.
Yes.
Who may be joined as plaintiffs?
Hmm.
All persons may be joined in one suit as plaintiff where any right to relief in respect of or arising out of the same act or transaction or series of act or transactions alleged to exist in such person, whether jointly, severally, or in the alternative, and B, if such person brought separate suits, any common question of law or such arising. Now, Your Lordship, subclause 3, Your Lordship. Who may be joined as defendants? All persons may be joined in one suit as defendants, where any right or relief in respect of or arising out of the same act or transaction of series acts or is alleged to exist against such person, whether jointly, severally, or in the alternative. B is if several suits are brought against such person, any common question of law is arise. So, Your Lordship, this is abundantly clear that defendant cannot, you cannot give a relief to defendant in a suit by these two provisions, Your Lordship. He has to be co-plaintiff. He has to take either if he file a counterclaim, then he can get a degree. But without a counterclaim, it's not possible, Your Lordship. Because counterclaim says your counterclaim is also there, Your Lordship. Your Lordship, I just order to rule 2, I just say that is also important, Your Lordship. That is also relief, Your Lordship, I say. Order to rule 2, Your Lordship. Order to rule suit to include the whole claim.
Yes.
Every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of cause of action, but a plaintiff may relinquish any portion of his claim in order to bring a suit within the jurisdiction of the court. Your Lordship, is very clear that it is the plaintiff who can lodge the claim, Your Lordship. Whole claim, that's order to. Then then 3 is omission to sue for one or several reliefs. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of the such relief. But if he omits except the leave of the court to sue in all such relief, he shall not after sue for the relief. For the purpose of this rule, such an obligation and a collateral security for the performance of successive claims arising out of same obligation shall be deemed to respect considered, but no one cause of action. Your Lordship, this clearly says that here possession has been excluded. They have stated they are not in possession. The evidence has not come and in the plaint also they have not said. Question is, in view of section 34 of Specific Relief Act, that cannot be done, Your Lordship. Section 34 Relief Specific Relief Act, yes.
Okay.
Section 34, Your Lordship. Discretion of the court as a declaration of status or right. Any person entitled to any legal character, my Lord has got it. Section 34.
Got it.
Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such a character, such a right, and a court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration omits to do so. Your Lordship. Here it's a specific bar is there. By this provision, Your Lordship, the issue that you cannot pass a decree in favor of defendants is the provisions are absolutely clear. There are no judgments are required. Exceptions are very clear. That if either you have to file a counterclaim you can give that because counterclaim becomes a separate suit itself. So as a result, that's a different thing. Or you transpose him as a plaintiff by order it or sorry, transpose the defendant as plaintiff, then correct. But plaintiff, the defendant has not authorized the plaintiff to sue his matter. So how can?
May I submit one thing, Lordship? They are jumping.
Let him complete.
Why you are jumping again?
No, I'm not jumping, Lordship. I'm submitting only one thing.
Okay, well, all right.
First appellate court is to decide on the point to be determined. Lordship, in this particular case, we have to give the reply on some points. But they are arguing the case on this point, they're jumping to another thing, little difficult.
That is my discussion.
They have to make a submission of the point to be
My
determined.
learned friend need not tell me how to argue my matter. He need not tell me, instruct me how to argue my case. He let him argue his own case in his own way. He need not instruct me. This is just intention to disturb the flow, Your Lordship. That's the only thing. That's the only intention.
Okay, continue. So as per section 34 of the Specific Relief Act,
because he has not a declaration of title. Now, it's so for declaration of title of the suit that, not beyond that. And if Your Lordship will see, possession is not declaration of suit land, the sale deed of 1957, and the declaration suit file was the 2013, Your Lordship, after a span of 56 years. There's delay, it's part by limitation also. That those points I'll agree, but as giving that brought out limitation also comes in because suit is not maintainable. Because now what they are trying to take the limitation from the rent. They have been collecting rent, they are collecting rent. If it's for collection of rent from the buildings, then it says to under Rent Act, not civil suits. Plus, there's nothing, no agreement of tenancy has been produced, nothing has been, no rent receipt has been produced by them that this is tenancy. So that also goes. The question, the cause of action also doesn't come in. So all these things take together, possession, they have admitted possession is not there by their own deposition. And once possession is not there, declaration of title is a paper decree. You cannot get, this court cannot give a paper decree to anyone, Your Lordship. So, then order 1 rule 4 is also there, Your Lordship. Order 1 rule 4 says, court may give judgment for against one or more of joint parties. Judgment may be given without any amendment for such one or more of the plaintiffs, no defendant has made it, as the case may be found to be entitled to relief for such relief as he or they may be entitled to. Then against such one or more of the defendants, as such found to be liable to according to the right. Here, this code is very clear, Your Lordship. Decree can be only against the defendants. It can be in favor of the plaintiffs. You cannot, in a suit, you can ask for decree for yourself, and that decree should be against the defendant. You cannot ask for decree for the defendant also. These sections are very clear on that point. Then counterclaim comes out of order 8 rule 6 that also I have. Order date rule 6A, your lordship, counterclaim by defendant. My lord has got it. A defendant in a suit may, in addition to his right of pleadings, a set of under rule 6, set up by way of a counterclaim against the claim of the plaintiff, any right or claim in respect of the cause of action accruing to the defendant against the plaintiff, either before or after the filing of the suit, but before the defendant has delivered his defense or before the time limit of delivering defense expired, whether such counterclaim is in the nature of claim or damage or not, provided that such counterclaim shall not exceed the pecuniary limits of the judicial rule. 2. Such counterclaim shall have the same effect as a cross suit, very important, so as to enable the court to pronounce a final judgment in the same suit. Both are in original and the counterclaim. The plaintiff shall be at liberty to the original written to file a written statement in answer to the counterclaim of the defendant within such way as may be fixed by the court. The counterclaim shall be treated as plain and governed by rules. It's very clear. So here there is no counterclaim or anything defendant 1 to 6. So the court cannot give a decree in favor of defendant 1 to 6, your lordship. That point is absolutely clear, your lordship. Because this point was raised by my learned friends, that's why I am clarifying it with the threshold itself. Then, your lordship, I take your lordship to the deposition of the DWC, your lordship, which was starting page 158, your lordship. The deposition of DW1 is null because you have to keep the name, otherwise there are two DW1, your lordship. Nolin Miki, he is defendant number 6, and he is plaintiff, appellant number 1 here. DW1, page 158, your lordship. He starts at that. Then, your lordship, page 159. As
Yes.
per exhibit Kh and exhibit 8, there is no mutation in the main of Sutiram Miki, Kantiram, and John Miki. John Miki. The purchaser never mutated the names in the separate suit land. Then, your lordship, here I have raised an objection also, your lordship. In between, if your lordship see in middle, here in this suit, we have never filed any our counterclaim. Here we are seeking the declaration, the exhibit binds the so and so, your lordship. Here he has stated that in the middle of the page 159, your lordship.
159 is the evidence of DW1.
Yes, DW1. That's I have stated that. That's why I'm showing that. First exhibit call is there. That is there mutation. Then here in the suit we have never filed our counterclaim. That means the defendant he is also seeking a declaration. The exhibit call binds that so and so. So then, if your lordship go to his cross examination also. His cross examination also there. The documents are mentioned. Your exhibits are mentioned here. All the exhibits are mentioned. That's why I'm not taking trouble with your lordship this thing. Then your lordship.
So in which part it is stated that he has not filed any counterclaim?
Yes, page your lordship 159 between here in this suit, in middle of that binding upon the after the writ petition. It next sentence, your lordship. Here in this suit, we have never filed our counterclaim. Here we are seeking a regular exhibit called binds the capital sense. Then he has stated in his cross also that they are not the co-owners of suit. Let page 161 the cross start, your lordship. It is not a fact in the between that the legal heirs of late John Miki, Kanti Miki, Sutira Miki are co-owners of the suit land. He has categorically stated in this thing. Then, your lordship, there is one DW2 with an independent witness, your lordship. His evidence is next one. It starts from 163, your lordship. He said, my lord is 163, para 4. I say that Kepanijal village people have by collecting money from door to door in the year 1957 has purchased the suit in the name of village head persons, namely village head person, Boloram Mikir, Kanti Mikir, John Mikir, Sutira Mikir, by registered deed dated so and so, as Raj Goria from the Pattada Hirenram Fukon so and so, paying so and so. Since the date of purchase of Kepanijal possessing the land, and now also they are in the possession of the suit land. At the time, I was so and so. Here, your lordship, categorical statement is there. It was they say it has been purchased in their name only for the for purpose of this thing. Raj Goria of the appellant number 4, your lordship. Then para 6, if you lordship, father of the plaintiff so and so, all the during their lifetime had not claimed any portion of the auto land because they purchased the suit land on behalf of the people who have Rajgir. As such, the suit land plaintiff was not. The plaintiff has signed the suit after 56 years from date of purchase. Sir, there is not legal. Your lordship, he is an independent. He has given evidence. Yes. Then, if your lordship, his cross is also there. Your lordship. Because this has not been displaced by the cross also, your lordship. DW2. Page 173, your lordship will see. Page 173. Your lordship, page 1. He said, I am not a member of Kepanel Gauss Undan, so he's not a member. Then next, if your lordship will see, it is not a fact that a plaintiff have the right title and interest over suit land. It is not a fact that the suit land is not under possession of Kepanel. So it is this in cross also. It cannot be the position is there, and they have admitted the position is at no point of with them since 1957, your lordship. Then, your lordship, DW3 is another independent. He's DW3 is he is also one of the applicant, your lordship. See, he has in page 175 he has stated in para 3 end, your lordship. Since the date of purchase of suit land is under possession of Kepanel rights, and at present also in the disputed land, plaintiff has no right and possession. This has been there. So in the cross also I'll show you a lot that nothing is there to suggest that it's not there. Your lordship, page 183, if you'll see. In middle, they refer to revenue case also. Revenue case subject to decision of present suit. If I just read it in exhibit Q, the suit land has been shown as mutual in the name of original purchasers. Exhibit Go was issued in the year 2000. As apparent from exhibit TO issues and exhibit Go, which was based on the order date so and so, RA number so and so, by board of events shall be subject to decision of present suit. It is not a fact that suit land does not belong to Kepanel, and as such, the public has no right, title, interest over suit land. The plaintiff number 1 has no right to a suit land. General public was registered in the 2006. The Kepanel Undan Committee used to collect rent from the material market. So I have not submitted, your lordship. He as secretary, he has deposed, and that has not been done. Again, he was cross-examined later on also. Again, your lordship will see. He said. He said the original owner of the suit land, Hidden Program so and so. He said, though I came to know the name of children so and so, I have not got your lordship said. Then if your lordship will see, he has referred to all the documents. Your lordship, the exhibits have referred to the exhibits. I need to take a trouble to the exhibits, your lordship. So that I have already shown that the exhibits are listing the collection through the in custody of first and not be produced. It is not a fact that production of income. So your lordship, there's nothing on that, your lordship. Then, if your lordship will see, these are the deposition of this thing. So, if your lordship, the judgment doesn't consider the deposition of the DW, that means DW, there are two DW1, DW2, DW3, and exhibits. Exhibit 5, there are total, I have collected, there are total 19 exhibits. That has not been considered, your lordship. Then, if your lordship will see the sale date, if your lordship will see, page 186, sale date is, it is here. Actually, your lordship, it should be come above seller actually. While writing, the seller and this thing are in the same line, your lordship.
Page number?
Page number 186, that sale deed, your lordship.
186.
Sale deed, 186, 187 just sale deed, and the Assamese version is originally is 188 and 189, your lordship. If your lordship see in between, here, page 186, if you see, your lordship, these are the purchaser's name, village. On behalf of Rajgir, village should be here. He cannot. Hiren Ram Fukan and Biran Ram are the owner of the property. Rajgir is never the owner of the property land. It's a seller. He is not a seller. Rajgir is not the seller of the land. They are purchased. So on behalf of, they take advantage of that because the line slightly comes down because in writing and they put in one single line. So seller and this thing, that's why if your lordship see the original also, it is there. It is at page 188, your lordship. Raja Garma Journal Likhito. It should be slightly above. That's the only thing. But that's why the board has clarified that situation, but it's not that because this Balaram Fukan and this two Fukan brothers has not sold the property on behalf of Rajgir House, this thing. Because they are the original owner of the land. If your lordship see the here also, if you see both, if you say that it at 186, so both are sons of late Nobin Ram by caste into profession and so on within the region that due to our sellers need money on the receipt or consider amount so and so only from you the sale has been right stated in your name. We executed a deed in favor of you and according to handle position of land described by you. Your lordship, it is because Rajgir is never the owner of the property. It has so that slightly that they have taken advantage of that situation, and the court has also done that also. Then your lordship will see this. I have shown your lordship this translated copy of this exhibit called your lordship, exhibit 2, where if your lordship will see page 200 remarks Rajgir this thing. If your lordship will see here 1 to 5 and so and so here name of the pattadas in pattadas so and so 4 here remarks it is Rajgir field. It's a Rajgir field. It's a this thing, no? So here if your lordship will see, then page 203 is the periodic first patta. These have not been challenged by them, your exhibit go. It was issued in the year 2000. No? 12, it is 12/10/2009. This was on 12/10. Date originally also there. It was 12/10/2009. This periodic patta has been given in 12/10/2009 in name of the appellant number 4, your lordship. And the suit was filed in 2013, your lordship. And these documents are not challenged, your lordship. Then if your lordship see page 208, on the basis of the land revenue was paid, your lordship will see page 208. Kapanijal Government Committee, your lordship, name of the pattadas. So your lordship will see here, then same thing in next also, 210 also. So all these documents are showing that appellant is the even GMC receipt also shows. So lordship, GMC receipt is money receipt page 218. Check cash to from Kapanijal Government Committee, 21/4/2015. Then your lordship. Tax also, GMC tax also has been paid Kapanijal, your lordship, which is that page 219, your lordship. We'll see the name of Kapanijal here also, your lordship. If 219, if your lordship, Kapanijal is a left-hand corner, your lordship, left-hand this side, Kapanijal Government Committee, GMC tax receipt. The GMC money receipt is again tax receipt. So all these things are there. Then your lordship, this defend number 1 and 2, your lordship, they are stand. They have find a WS there, your lordship, denying the their stand, it is been reflected in the Board of Revenue. Their affidavit has been stated here, your lordship. Page 230, 224, your lordship. These are different number 1 and 2. Here go put that also. 1 sheet 8, 1, 2, 8, 3 and 4. 1, 2, 1, 3. Jonaki Mikir, so I met Sandra Mikir, so on Sabi. Different number 1, 8. Jonaki. Different number, say no? You have not challenged. আরে রকম বোর্ড অফ রেভিনিউ তে বলছি হ্যাঁ আরে উনি এটা কোন কেটা ডিফারেন্ট নাম কোন ডিফারেন্ট নাম কি 20% হ্যাঁ different 1 and 2. Your Lordship, this is assigned by different 1 and 2, Your Lordship. If Your Lordship, para 3, page 1, 231, that we have come to know that
Page number 200 and
224, Your Lordship. This was filed before the Board of Revenue. 23/6/2008, Your Lordship. Para 3, Your Lordship, that we have, my Lord has got it.
Got it.
That we have come to know that Kapanil Rice, by contribution of rice on 13/3/1957, Your Lordship, our father, Sutiram Mikir, along with Boloram Mikir, Kantiram Mikir, and John T. Mikir, as Rice Goria, had purchased from Hiranam Bhukan and Viranam Bhukan, resident of a plot of like 9 meter 4 kora 1 as a dark number so and so village kind of George Moja Beltora by registered deed of sale number so, and since the date of purchase, the rice of cattle has been possessing the land by occupying same at present and also occupying the same. At present, the patta number so and so is that. So here also you will see this different number 1 and 2. They have categorically stated that it is possession of the appellant number 4, Your Lordship. Now, how can they give this? Then if Your Lordship go with the para 5, we have come to know that by reading of the sale deed dated 13, that the said land is not the individual property of her father, Sutiram Mikir, along with Boloram Mikir, Kantiram Mikir, and John Mikir. Since the rise of Kapanijal has purchased the land as Rice Goria, in the said the land, Waris of Sutiram Mikir and John Mikir will have no right. Then if Your Lordship, next para, be it be mentioned before filing the case, we have not seen deed so and so and land for so and so. We have filed a mutation case. Now we are fully aware that land purchased by Rise of Kemare, as such, we have no right along with the worries of the so and so. This is the respondent, plaintiff's father's, Your Lordship. So the mutation may be granted in favor of President Secretary of Kepan and Johnson. So So Your Lordship, this is absolutely. Then next para, if Your Lordship see, next page, para 7. We state that we have not filed any case against the order that is so and so passed by Assam since we came to know from our father Sutiram Mikir, Boloram Mikir, Kantiram Mikir, and John Mikir, purchased as Rice Goya in the name of the people of Khepanja, and since the date of the purchase is under peaceful by the village people. So we pray the land record may be corrected in the name of Khepanja so that nobody can claim it. So it is very clear, Your Lordship, because here they have taken a stand that it belongs to this thing. Their appellant number 4. In the suit also, defendant number 1 and 2 has a suit is not maintainable. So now, on the basis of this, how can the court can grant a decree in favor of this as a ownership to these people? Title. They have categorized a possession is not since 1957. We are not in possession. Possession, if they are dispossessed, there's the date of dispossession has to get nothing has been stated. And still a plaintiff are in possession of the whole thing, Your Lordship. Now, in the background of this, Your Lordship, I'm coming to a judgment, Your Lordship. That's the case. How the judgment is erroneous, it will be reflected, Your Lordship. It starts from page 26. Short judgment, Your Lordship. Page 16, Your Lordship. I just read because it's a short judgment. I read the judgment. The case of the plaintiff is that late John Mikir, father of the plaintiff number 1, late Sutiram Mikir, father of plaintiff number 3, and defendant 1, and late Kantinam Mikir, father of defendant 2 and 2, and late Boloram Mikir, husband of defendant 4, and father of defendant 5 and 6, had purchased a plot of land measuring 9 biga, 4 kata covered by dark number so and so from late Hirendra Bhukan by way of registered sale deed dated so and so, described in Schedule A, and after the purchase of the, Your Lordship, land has been described in Schedule A, but no relief has been claimed under Schedule land. They said land has been described in Schedule A, but relief has been gained under Schedule B land. They do different land. Here, that's why I read the thing. Describing Schedule, and after the purchase of the land, the names of the partner were mutated in the records of right after settlement of the original partner of dark number were changed to partner of 751 and dark number 303021. The purchasers, when see here, the purchasers, they have not said plaintiff. The purchasers were in possession for a period of 30 years after settlement of capital. Purchasers with the appellant number 4, they are in possession. We also agree. They didn't say the plaintiffs are in possession. Purchasers also are in possession. Because they are not, they just use the word purchaser is that to mistreat the whole thing. After a settlement, we copy button conferring state of land, a plaintiff applied for so and so before the additional label Kamrup by 3 separate petitions to get the name written over a plot of land measuring 10 by so and so, and the land measuring so and so for a total area of land measuring so and so in place of deceased landholders Patara, Sutiram Mikir, Kantiram Mikir, John Mikir, and predecessor interest of defendant 4 to 6 late Bororam Mikir. Defendant 10 and raised has raised objection before a settlement officer, this case number stating that they are the absolute owners in respect of disputed land by virtue of purchase on behalf of rights by registered sale deed number so and so. It is pleaded that the suit land which was originally used for agriculture was developed in by people the locally, and now the same has been converted into a commercial land. During the course of time, the land was used by some trade, and now it has been developed into daily weekly market under name and site Lokhra Bazar. Lokhra Bazar is nowhere, your lordship. This is very important. They are claiming Lokhra Bazar. Lokhra Bazar, this plot is a separate place. Lokhra Bazar is the suit land is around 500 meters away from Lokhra Bazar. And towards the western part of the land, there is a school as well as the office of Mahila Samiti, which was established in 2007. The plaintiff have no objection to establish a school and a Mahila Samiti. And in the remaining 9 Biga Wanka, there is a regular market having at least 100 traders, and there are some tenants on a monthly basis. Also, the plaintiff collected rent from the weekly markets of the traders or tenants increase of rent collection daily, so and so. So they have said we have been collecting, they have not shown any evidence to that collecting any rent. Nothing, no evidence of it. The defendants started collecting rent from providers, and they are owners of land. And from 1/7/2011, the defendants are collecting the rent from the market without it. This date of 1/7/2011 was brought in to save the limitation. If this is taken to a date of starting point of limitation, then your lordship, it's for the purpose of claiming the rent only, not for any other purpose. This cannot be a cause of action for the purpose of declaration of title, because declaration of title sale deed was of 1957, and it's after 56 years. So, in view of limitation, your lordship, I need to trouble your lordship. Your lordship, Limitation Act, if your lordship see part 3 of the Limitation Act, schedule, your lordship, suit relating to declarations.
Yes.
To obtain any other declaration, there are 3 years, where the right to sue first accrues, your lordship. This 3 years, your lordship. So that is, this cannot be the cause of action for this, because the mutation, everything was to Board of Revenue, it went before also. So that they filed a suit here. So question of that suit is hopelessly barred by limitation also. Because not meant. Then I take your lordship. The defendant started, your lordship, I will page 17, your lordship. Hence, the suit for declaration of your lordship here is very important. Once defendant collecting, hence this suit is for declaration that plaintiff has joint right, title, and interest along with defendant 1 to 6 over scheduled B land, not scheduled land, is suit land, and are entitled to collect rent from Lokhra Bazar along with other reliefs under cause. Defendant contests a white separated. Defendant 1 and 2 in the written statement averred that the suit is bad for non-gender of parties. Yes, stated, and the title and position of suit land has not allowed to be decided, and the decision of Adam Board does not confer absolute title over suit land in the name of Rajgriha, and the plaintiffs and defendant are entitled to equal opposition. Your lordship, that affidavit which I read, this is contrary to that. Affidavit, they said they have category which the Board of Revenue which I read before that, your lordship. That category stated that it is a Rajgriha, that in the Board of Revenue, that category stated that the land belongs to the Rajgriha and they are in possession of the suit land, which I have already read to your lordship. Now, defendant number 3, he is the Subin Mikir. In the written has stated that land was never purchased on behalf of Kapanji, and the title and position of suit land has not been at all been decided. And the decision of Order Board does not confer any absolute title over suit land in the name of Rajgriha and entering the defendant, never allow the defendant 7 to collect the rent market entering so in the corporate. So, your lordship, he is supporting the plaintiff, defendant number 3. So he was examined as DW to that he's DW1 Soven Mikir. We have to say that way. And DW1 Nalin Mikir. Then defendant 4 to 11. These are the appellants before your lordship. In the written say have averred that the suit is not maintained being barred by law of limitation, and have categorically stated land measuring 9 bigger 4 kata was purchased by then John Mikir, Sutiram Mikir, Bolaram Mikir, and Kanti Mikir on behalf of Raj Guria by registered sale deed number dated from the original owner named Virendra Bhagan and Hirendra Bhagan. And after purchase of the land, same is in possession of Rise of Khepan Rival. They have not stated they are in possession. Even judgment has a record they are not in possession. We have categorically stated as the same being maintained by them in the board of has set aside the order of settlement or declaring the title suit in favor of the plaintiff, to which the plaintiff preferred a writ petition before the Honorable High Court, which ultimately upheld the order sum of the board and remanded the case back directly referred to substantial claim before the Board of Revenue. And according to defendant 2 and 3, file a petition dated 23/6/2008 and stating that their father, along with Bolaram Mikir, John Mikir, has purchased the land on behalf of Rajgir and the state. You all are defendant 2 and 3 again. He has stated these things. From Virendra Bhagan and Hirendra and other after purchase of land, same is in possession of Rajgir. So here I may pause immediately. If this is the stand taken by the, how can the court give a relief that defendant 2 and 3 are also the owners of suit land? Because they have categorically said the reverse thing. Because the court cannot go beyond the pleadings also. It is further said that Rise of the Khepan has constituted an Unnayan Committee headed by defendant number 8 and 9, and they are running the market of sale, proceed the market and used to develop the areas to no rise. Then for the then issues are framed, whether there is cause of action, whether suit is maintained in present, or whether suit is barred by limited, fact of defect of party, whether plaintiff has right title interest over Schedule B land, not Schedule A land is not basing your lordship. With the defendant number 1 to 6, whether the plaintiff has entered realized rent, so and so Schedule B, with the plaintiff has entered decrease 200. Both the parties, here your lordship, this is very important. Both the parties have adduced evidence, exhibited documents in support of the contention. This your lordship will see the last page is totally missing. If you are saying it here, page 26, if your lordship will see 37, sorry, 27, if your lordship see bottom, there is the defendant documents exhibited nil. Page 27. Here said I have exhibited documents, I have admitted to exhibit documents. I have heard that so and so. Then issue number 1. The plaintiff has stated that the absolute owner of the Schedule B land on the strength of sale deed, not Schedule A land here. Now Schedule A, they do two Schedule on dated which was purchased by the predecessor, and they have been collecting that for until 36/2020 when the defendant has started collecting, claiming that plaintiff has no right to. Your lordship, I may pause it. Although they have not produced any rent receipt, no tenancy agreement, nothing of that. That till 2011 we have been collecting. After that we have taken over. So that means in that case we have dispossessed them. According to 2011 we have dispossessed them. Then there is a suit for recovery of possession has to be there. It is clearly admitted that by this statement they have clearly admitted that we had disposed and we had started collecting rent from them. So in that view of the matter, they should have claimed recovery of possession that we have been disposed on this. They have not said we have been dispossessed. So this is very important. No title over the suit as the same was purchased on behalf of the Raj. The defendants have averred that the title and possession of Schedule B land have been declared in favor of by the Assam Board of and ordered, and the Schedule B land was purchased on behalf of registered sale deed so and so from Hirendra Bhagan Bora, since the date of purchase, the land is in occupation of rider and the plaintiff has no right to. This categorical statement is there. Don't deny of the sentence. There is no evidence to the contrary here. So there appears to be genuine dispute by the fact that plaintiff disclosed the cause of suit. Issue number 2. The defendant has taken the plea the suit is not maintained in the present form, but there is no specific in the written statement to show why the suit is not made. A casual ever made in the written is not enough, and the defendant has to impress upon the court to show why the suit is not made in the present form, and in absence of such proof specific, the court cannot come to a definite. Moreover, the fact disclosed in the plaint as well documents produced in the contest that suit is maintained and therefore plaintiff has better record. And issue number 3 is there. This is very important. The defendant has contended that suit is barred by law of limitation. Now, this is a suit for declaration, Your Lordship, and was instituted on 1679. And the plaintiff has evidently paid that they were collecting rent from Lakhrawa functioning across Schedule B land till 13/6, and from one side, the defendant has started collecting rent from the barrister and the Lakhrawa Bazar. The cause of action for still arose when defendants restrained the plaintiff collecting rent and traders so and so. Hence, the suit is instituted so and so. Same is within the period with Article 58. Now, let us read Article 58, Your Lordship. Article 50, I've already read it 3 years, Your Lordship. Now, they have, on the ground of non-collected, they have not shown any document to show that they have collected rent in 2011. So the cause of action goes away. So this was a specific plea taken by us and has not been answered by the court. Then issue number 4. The defendant has taken a plea the suit is bad for non-judicial necessary, but the pleadings in the written statement is silent as to who are the necessary and whom the plaintiff have not been made a party. The true trace for determining as to whether necessary, but you know, it is necessary. Let us keep it. Now 5 and 6, your next page. Has both the issues I propose to examine together. Exhibit 1 is a sale deed number so and so, dated 13 says by which it is shown the suit is ambiguous so and so. This exhibit 2, no, 1 is a schedule land. They have category set what schedule land is exhibit 1. No relief is claimed on exhibit 1, Your Lordship. And it is shown because they have claimed on exhibit 2, not 1. And John T. Vicker purchased the land measuring so and so on Kasar, so purchase Hirendra Bhukan. Certificate copy, exhibit 8 is certificate copy Jamavani KP party of respect of said plot showing the names of 4 by exhibit and draft Jamavani of KP so and so. PW1 say Pulin Mikir and PW2 Vijay Tamang both deposed that land measuring Pulin Mikir, right? And 9, Your Lordship, here, if Your Lordship will see, these people have deposed. Nothing has been stated, Your Lordship. Pulin Mikir, huh? Sorry, PW, they have, sorry, I'm sorry. PW, they are the plaintiff. One and PW, Vijay Tamung has devoted. You know, Vijay Tamung is one thing I have to point out here. Vijay Tamung is a person who is dealing with the business of selling of land by on commission base. So he is an interest. Because he has categorically stated his deposition. Vijay Tamung, he is a, I think he is a broker of selling land, Your Lordship. Land broker. Vijay Tamung. So, Your Lordship, because PW2 is deposition, if I just he has categorically stated.
Merely because his profession is a land broker.
Yeah. No, I'm not saying that. I'm not saying that. I'm not saying that he cannot depose on these issues. He cannot, when the sale deed was made, he cannot depose on these issues. His evidence, I'm saying his evidence is not relevant for the purpose of deciding the dispute, Your Lordship. Has deposed land basing 9B covered by dark number so and so, KP water was purchased by jointly by so and so from Hirendra Mikir by registered tail deed. So this document 1957, how is known to me? And accordingly, the names of purchase are muted in the record of right after settlement of the dark number and patta number subsequently changed. It is also deposed that the plaintiff applied before the additional deputy commissioner Kamru to mutate the names of a plot of measuring so and so by initiated in place of original purchaser, raised objection before settlement, and that the original owner of disputed land was purchased on behalf of the rise. This is very important. It is also deposed the settlement of allowed the mutation in favor of plaintiff, which was challenged before the Assam Board by way of appeal, and the order of settlement was set aside, and the plaintiff approached the Honorable Gode, and the same was disposed of with a direction to the Assam Board for proper adjudication of respective claims of the parties for mutation of names, and according to Assam Board of Revenue, observed both the title and position to respect the disputed land, the rise dispute are with the rise of Kipanage. So Board of Revenue has decided in favor of appellant number 4. DW Sri Soven Wiki. They put DW, not 1, 2. Because DW Sri Soven Wiki. No number has been given. In his evidence, has supported the case of the plaintiff and has categorically stated that land was never purchased on behalf of village of Kipanjal, and the general people of the area cannot claim right over suit land. No names are original, so the right giver deposed. Now, during cross-examination, PW1 stated that with the consent of all the parties of the school, he was established over land and 15 collected land, but no receipt has been made submitted. It is no receipt. Your Lordship will see. No, they have admitted no receipt. So, here is a question of them collecting it to 2011, Your Lordship. They have admitted. It is also stated in cross-examination that the land was not partitioned. It was also stated cross-examination since the land was purchased in the year 19. Hence, he is not aware of who was in possession of 1970. That is very clear, Your Lordship. PW1, he is claiming to his father. He doesn't know who is in possession. This is very important. He does 57 to 97. He doesn't know who is in possession. That means even after 90, since the question, they have not claiming any possession, they have not stated that. That means they have not in possession here that also. He has stated. Then the evidence of the plaintiff witness are clear and cogent and the defendant have failed to revert the demolition test during incisive cross-examination. In cross, I have proof possession was not that they have admitted possession was a rise. Owner, the land was in that they have PW1 I have said. So how can a court come to this conclusion? From where is the material to come to this conclusion? The incisive cross I could not decide because page 67 onwards, if you will see the cross examination is very clear. PW has admitted everything in our favor. The defendant, in an attempt to discredit the testimony of plaintiff witness, has failed to impress upon to dilute the claims of the plaintiff. Moreover, the sale deed dated so clearly indicate the land was purchased by Sutiram Miki and Baloge and Bidana. The retitle of sale deed does not in any way convey that land was purchased by Rice. The board will say that, Your Lordship. Because if this view is taken, Your Lordship, how the name of Rice has come there? The sale deed. We cannot be seller. So this is on behalf of Rice is there. So on behalf of, instead of going up, it has come down. While writing the deed writer has written that to Your Lordship. So that advantage they are taking. Even the trial court also they have taken that view. Land was purchased and above its purchase of rice. Apparently, it is admitted that on the part of the land, there is a school functioning. The Mohila Samina plaintiff have no objection to function. Exhibit 5 shows the holding was issued the name of plaintiff in respect of school plan by GMC Exhibit 7 and KP Pata number 150, showing the name Sutiram, Miki, Bolorami, and John T as Pata in respect of while Exhibit is a draft Jamabandi KP9 so and so. Your Lordship will see there is no such admission on behalf of dependent in the cross also. Your Lordship, because cross has not been considered. Here, Your Lordship, there is the Your Exhibit 5 was issued in the name of dead person, so it cannot be done. Exhibit 5. Then the plea of the defendant that Assam Board of Authority want to decline the right title suit in favor of Rice on the reasoning that the purchaser could not assign any valid reason as to why the purchase suit and jointly, and hence it can be safely present the suit land purchase on behalf of cannot be accepted, not tenable in law. So from where he has got when the specific pleadings are there, my examiner have laid evidence, cross-examine, nothing could be asserted. While crossing PW1, he has stated everything in my favor. Possession was with me. So how can the recital say it should be before Borabor? Such interview would not well justify that. The existence of a school Mahila Samiti is one part of the functioning of daily market as weekly market by trades accepted. The dispute is only respect of collection. Here is right. The dispute is only respect collection of rents who were restrained by the defendant from 1/7 a defendant 1/2 and supported. Your Lordship is there is no specific pleading on that issue. There is no documents also to show that they have been collecting rent till 1/7 before 1/7/11, Your Lordship. So there is no evidence that defendant 1, 2 and support the case of the defendant 1, 2 and 3. This is also wrong statement. Only defendant 3. Defendant 1, 2 I have shown the WS. They didn't contest that this is not maintainable. And everything is there, defendant wanted. Then in respect of collection of rent, yeah, this is very important. In respect no documents are placed on record by them to show the amount of rent that is collected from daily, weekly suit land. Here if there is no documents producing any rent receipt, how can they say that rent I was collecting rent before that? And they were collecting before that date. I started referring. So this statement is very categorically, Your Lordship, that their whole cause of action goes falsified by this statement also, by record evidence finding of the court also. If there are no document is placed on record and nothing is there, so the tenancy is not there established. No evidence placed to show that extent of entire share of respective rent collected from the market. Hence, there is no evidence on record to show that there is monthly income. This is very rupees 3 lakhs from the market. Regarding internal share of collection between the plaintiff and defendant 1 to 6, it is a matter of internal from where this has got internal agreement with. There is no pleadings to that effect. There is no question. It's an internal agreement with the party division of the rents. Since there is no document of this thing, and hence liberty is given to make an apportionment of share equal among the party, which is of course can be decided in conclusion of the. So Your Lordship, this is not the prayer also. This is not the relief claim by the plaintiffs also. Hence, this court is of the view that no decision is required to be given by this court in respect entitlement of pertaining to rent collected. So if you don't give a finding on the entitlement of collection, who is the question of cause of action, the question of their refuse, they are dislodging from collecting rent, Your Lordship. In the instant case, the plaintiff have clearly and with corroborative has substantiated their claim and credibly established the title of the suit land, only title. Moreover, the document adduced by the plaintiff support of the contention suffer no effect. The plaintiff witness corroborated the case with clear convincing evidence with no considered material point and there is no question so and so. Now, from a discrete scrutiny of the entire available on record, both oral and document, it transferred the plaintiff have been able to substantiate a claim with cognitive reliability, and the defendant have failed to discredit the evidence on record adduced on behalf of the plaintiff. Therefore, defendant does not come within a reliable. Your Lordship, contrary, Your Lordship, I have shown the deposition category. This is totally incorrect observation, Your Lordship, and issue of decided. In relevance of discussion made also it says. Thus, Your Lordship, the order. The suit is decreed on contest with cause. The right, title, and interest of the plaintiff in respect of suit line described in Schedule B is hereby declared jointly. Defendant want to say the plaintiffs are entitled to collect the rent. Traders, Lokra Weekly and Daily Market to extent of share they are entitled to agree the jointly collect. So, Your Lordship, this is not the prayer also. Then, if Your Lordship see next, Your Lordship. The appendix, Your Lordship. They have said two witnesses are PW and PW, and sovereignty is already DW. Here, Exhibit 1, copy of the registered deed. Exhibit 2. Exhibit 2 is, Your Lordship, KP, this a copy of this. They claim on the basis of that exhibit here, patta number so and so. Your Lordship, here it is sent. I have shown Your Lordship all that because I have examined. So now in the case, Your Lordship is clear, absolutely clear. They have not considered by deposition, nothing of that. Their admission, and the court has gone beyond the jurisdiction to give relief which are not the pleadings, Your Lordship. And as such, Your Lordship, the judgment has to be set aside by Your Lordship and highly objective. Limitation also I have said, barred by limitation because I've already pointed out.
Yes, Goswami.
May I submit also? I am the plaintiff in the original court also. And suit was decreed in my favor. And present defendant has filed appeal against the judgment and decree passed by the trial court. So appellate court, as per judgment of the Honorable High Court and the provision of the CPC, the first appellate court being the law and facts, not a second appellate, it's a first appeal. First have to determine the point to be determined. As decided by this court in a judgment reported in, I'm giving only 1-2 judgments, which categorically stated 2017 3 GLT 761.
717?
The first
3 GLT?
2017 3 GLT 761 and 2018 4 GLT 403.
2018 4 GLT.
Though the first appellate court have to first determine the point to be decided. In this particular case, I have heard the arguments of the appellant. They are jumping from one point to another and thereafter another point to another. So my submission to be in this particular case, they first argue before this honorable court what point to be decided by the appellate court. Appellate court have to decide the finding of the learned lower court, and they are not arguing any point specifically what is to be decided by the appellate court. Honorable Guwahati High Court and Supreme Court has already decided that this is in the regular first appeal. Regular first appeal have to determine the issue to be decided. So this point has been decided 2018 4GLT paid 403 para 14. Point to be determination. Number 1 related
You
to
submit the judgment.
Lots. Page 403.
Page number?
Page number 403 para 14.
Yes.
May I read, Lordship? Because I am not pointing out the judgment at this point regarding my defense, but I am submitting on this point that this being a regular first appeal, First appellate court has to decide the point to be determined. And I have to give reply on the point to be determined. If they are arguing the case from the Lordship will find how they have argued. They have argued the case first from the point of cause of action. Lastly, in the cause of action, that what is the cause of action? That is the suit has been filed after period of limitation. Secondly, they have submitted that plaintiff has not claimed relief, alternative relief as per requirement of section 34 of the Specific Relief Act. Secondly, they are submitting possessory right, that we are not claiming position, recovery of position of the suit land. Secondly, we have not paid for consequential relief. So my submission will be at this stage. At this stage, if I start my arguments without deciding the point to be determined, it will be difficult for me. Because they have not pointed anything specifically in these arguments, what is to be decided by this appellate court. Because appellate court is a facts as well as on law, Lordship will decide. Because this is not a substantial question of law. First appeal. And in the appeal memo itself, Lordship will find how they have projected the appeal memo. Appeal memo, Lordship will find in the cause title. Lordship can list the cause title. How they have projected their case. Lordship will find the index. How they have placed the court before the appellate court. Lordship will find index kindly see before that. Appeal petition. Thereafter affidavit, thereafter judgment, thereafter copy of the plain, thereafter copy of the evidence. These should be copy of the plain, thereafter copy of the WS. Defendant number 1 and 2, 3, defendant number 2, 3, 4, and 5. These are the things, but they have placed like this humble. Now they have argued the case regarding everything, confusing everything. Regarding cause of action, Lordship will kindly see what they have stated. Only one point I am submitting. Regarding cause of action, Lordship will kindly see what we have stated. In our plain, Lordship, we have given a list of dates. Lordship will kindly see the plain. Copy of the plain at page 33.
Page number?
Page number 33 onwards, the copy of the plain starts. They have not read the plain, what has been stated in our plain. Page 33. Only one point I'd like to place. Page 33, Lordship got it. Now regarding cause of action, Lordship will kindly see para 24. Para 24, what they have argued that suit is barred by limitation. On this count, case will go. If that is the point to be determined, that there is the cause of action that arose long 1957 when this CLD was executed. This point alone, the case will go of the plaintiff or respondent. Cause of action, para 24. Parties are not getting single funding from the collection of rent from Schedule B with effect from 1/7/2011. Earlier till 1/7/2011, plaintiff repeatedly requested the defendant to give their share and allow them to collect the rent from the market to the extent of their share as they used to collect earlier till 30/6/2011. But defendant forcibly illegally debarred the plaintiff from collecting the rent from the market, which was set by themselves in 2006. Lordship got it? Now I'll take your Lordship to the reply to the para 24. Reply to the para 24. The Lordship will find at page 144, para 13. Para 13, page 144. What has been replied? That is a reply to paragraph number 2, 5, and 26. Lordship will find statements made in para 2, 5 to 26 are not correct. Answering defendant strongly deny the same. In this connection, answering defendant beg to state that since the date of purchase of the rice, Kherapani has been peacefully possessing the same without any disturbance from any corner since feedback. The Raj of the Kherapani have constituted committee, namely Kherapani Gaon Unnayan Samiti, and said committee is headed by defendant number 8 and 9. And Rise of the Kherapani through secretary and president of the said committee is running the market over the suit peacefully and by outcome of the said market, defendant number 8 and developing the area and also doing developing. These are the statements. Nowhere stated that denying the statement what has been stated in paragraph number cause of action. Nothing has been denied. Lordship is aware that denial of a statement in a plain cannot be evasive. Evasive denials mean admission, Lordship. Lordship is aware. May I read? Order 8. Order 8, Rule 4.
Yes.
Where a defendant denies an allegation of fact in plain, he must not do evasively, but answer the point in substance. Thus, it is alleged that he received a certain sum of money, he shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum, any part thereof, else set out how much received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it allegation with circumstances. So evasive denials is not a denial.
So what is the basis of submission that evasive denial amounts to admission?
Evasive denials mean admission, Lordship. Order 8, Rule 3. It shall not be sufficient for the defendant in his written statement to deny generally the grounds alleged by the plaintiff, but defendant must deal specifically each allegation of fact of which he does not admit the truth except damage. And evasive denial Lordship. Every allegation of fact on the plain, if not denied specifically by necessary implication stated to be not admitted in the pleading by the defendant, shall be taken to be admitted, except against the person under the subject. If there is no specific denial, that should be considered as admission. Secondly, Lordship will kindly say one thing. What they have stated that we have not produced any rent receipt regarding receipt of rent from the market. Whether they have given, Lordship, they have also not given anything.
But it is whose duty to produce the rent receipts?
Lordship.
Who has to produce the rent receipt?
Because we have not given the rent regarding collection of proof of rent regarding rent. That is why we have prayed for a relief that we should be given a decree for the amount. Lordship will kindly say again, Lordship, I will take you to the plain. Copy of the plain, page 33. What we have stated in our plain. Lordship will kindly see the prayer. Page 46.
Yes.
Lordship, we pray for declaration of right and collect the rent from the traders of Lockheed on
Which
local
pair?
Saturday, weekly market, daily market.
A,
local-
B or C, which pair you were reading?
I am reading page 46. Prayer in the suit.
Which pair? A, B or C?
B.
Yes.
And further declaration that plaintiff have got right to collect the rent from the traders of the Shari weekly and daily market organized and held by Schedule B land to the extent of share of the plaintiff and extend to the 75,000 in respect of the plaintiff number 1 and 18,750 in respect of the plaintiff number 2 out of the total monthly income of which 3 lakhs. Now Lordship will find in the judgment, we have not given a decree for recovery of the amount because collection is not by any receipt. We could not produce any receipt. They also did not produce any receipt. They have already stated that we used to collect the rent. That is why we have not get the relief for recovery of the amount. Only trial court has decreed the suit, declaring my right title interest and my share. Lordship will kindly see the judgment. Copy of the judgment, Lordship will page 32. What relief has been granted? Page 26. Suit is decreed on contest with cost. Right title and interest of the plaintiff in respect of the suit land described in Schedule B is hereby declared jointly along with defendant number 1 to 6. So that is why, Lordship, we could not produce the receipt. That is why that relief we have not been granted. Secondly, Lordship, if I start arguing, it will take time, Lordship. If I start complete the argument without framing the point to be determined by this court, then it will take time.
You go by the issues framed by the learned trial court?
They have not, Lordship, the regarding issue.
No, maybe, but you
if
go.
Lordship frame like this, Lordship, the issue to be decided by the trial court have to be decided by the appellate court, then I am ready to argue this case, Lordship.
Pardon?
If Lordship, they agree that issue decided by the trial court have to be decided by this appellate court without framing any point to be determined, then I can argue the case, Lordship.
Yes.
If they agree, Lordship. If they agree to that.
We have argued, I fully argued. But let him argue.
No, without framing the point to be determined.
Mr. Sodhuri has already referred to the points, issues framed by the learned trial court.
Issues framed by the trial court, they have not argued regarding all points. They have stated regarding point of limitation that they have started the
Cause of
limitation
action also, Mr.
and cause of
Sodhuri has
action.
argued.
Yes. Then okay, Lordship. Okay, if that is the case, Lordship. And then, Lordship, they have proof, they have produced that they have exhibited the patta of the schedule land, which has been marked as exhibit. How they have obtained the patta? Patta, Lordship will find they have annexed along with the suit land. Lordship will find at page.
No, but
page is very relevant. That is why I'm saying they have made a submission before this honorable court that we have not challenged the patta, issuing patta. This patta has been issued in 2008 on. Lordship will find the date. 12/3/2009. It may be noted. 12/3/2009.
12/10.
12/10/2009. Now I'll take your lordship to the page exhibit 3. Exhibit 3, that is lordship.
Evidence of our evidence. Main should be.
Exhibit 3.
And our main headings of the original record.
From original record, it has not been annexed. Exhibit 3.
কবে? Exhibit 3.
EW1.
I think C file lordship.
Yes.
Lordship will can say exhibit 7. It is a patta of 68 in the name of the plaintiff's father. 4%. Exhibit 7.
Yes.
That is of 1968.
Exhibit 7. Yes.
Exhibit 7.
Yes.
Lordship got it?
Got it.
Lordship. Then Lordship, I will take your Lordship to the
It was issued on 3/9/65.
65.
Yes.
Now I will take your Lordship to Kesa Patta. That is exhibit 3. The cause of action, why it has come, Lordship, I will. Exhibit 3, Lordship, got it?
Yes.
That is Kesa Patta in the favor of our predecessor during settlement operation. Now revenue paying receipt. Exhibit 4. Lordship got it? Revenue
Yes.
paying receipt.
Yes.
Now, Lordship, the land holding in our name of 2006, 2007, Lordship, kindly see exhibit 5.
Before palace.
$545, Lordship, got it?
Yes.
Holding number 545.
Yes. Yes.
This is the holding number in favor of the plaintiff. This is Lordship 2007, 6 and 7. Lordship.
Yes.
Now I'll take your Lordship. Holding has been transferred after Lordship the Assam Board of Revenue's order 219 of the appeal memo. Same holding has been transferred to their name after obtaining order from Board of Revenue. Why I have to file this suit? 219.
Yes.
This is the same holding. All holding number, Lordship, will 545. What I have stated, Lordship may note it down because it is same holding 545. Fraudulently transferred from our name. They have transferred the holding. This new holding has been transferred after order from the Board of Revenue. Board of Revenue is 2009. Lordship will kindly see Board of Revenue's order. I have given a list of dates. Lordship will find Board of Revenue's order at page 238. They have jumbled the matter, that is why, Lordship. 238 is a Board of Revenue's order. Everything has been done after Board of Revenue's order. 238. Lordship got it?
Yes.
This order is dated 1/12/2008.
Hmm.
Very important, Lordship.
Hmm.
Right. Board of Revenue's order is 1/12/08. And this holding has been transferred thereafter. And patta has been issued after this order. Lordship has already noted it down, Lordship. Date of issue of patta. What they have stated in 2010. 2009. After this order.
After settlement operation.
After settlement operation.
Hmm.
They have transferred after Board of Revenue's order. And we have challenged the Board of Revenue's order before this honorable court. Lordship will find the writ petition number 63 of 2009 245.
Yes. 246 is the operation.
246 is the
operative
order.
part.
Lordship
Yes.
will find it is submitted by Mr. Sharma that the petitioner number 1234 had filed title suit number 277 of 13. This is the present judgment, which is under challenge in the court of civil judge number 2, Kamrup, Guwahati, against the present respondent number 234 and some others. This petition may be disposed of as infructuous with the observation that order of the learned Board of Revenue that Iman will be subject to the outcome of title suit number Iman. So the order of the Board of Revenue on the basis of which they have got the patta, they have transferred the holding, is subject to the decision of the title suit.
Hmm.
It is submitted by Sharma that legal representative of the petitioner number 3 herein record of the title suit. The Talukdar Learned Council appearing for respondent 24 also submit that writ petition can be disposed of and pursued with the observation that judgment of the Learned Board of Revenue will be subject to the final outcome of the title suit filed by the petitioner. In view of the above submission, Learned Council of the parties, this consent order is passed, dismissing the writ petition as infructuous with observation that order that is passed by Learned Board of Revenue shall be subject to the decision of the title suit number 277 of 13. So this subsequent patta, subsequent transfer of holding as not holding the field. Because of this order, this court has already held that this is subject to the decision of the title suit. Now I take your lordship. Lordship will kindly see page 189 of the appeal memo. Again. That is a sale deed.
Yes.
Lordship got it.
Hmm.
Now Borabor Lordship. Sutoram Mikir, Kantiram Mikir, Boluram Mikir, John Mikir. Hang Betkusi. Borabor.
Hmm.
These are the parents of the present plaintiffs. They have purchased the land from Hirendram Phukon and Birendram Phukon. Neither the respondent hearing who have challenged this judgment and order has challenged, filed a suit challenging that these deeds should be rectified, showing that purchaser are the Unnayan Samiti, where they have stated there is no counterclaim to the effect that this property has been purchased by the Khelapani Unnayan Samiti, Khepenijan Unnayan Samiti. This sale deed has never been challenged that this should be rectified. There is no rectification, prayer for rectification, neither there is a counterclaim, neither there is a suit.
How their right can be.
How their right can be accrued. Now I'll take your lordship to their restitution. This sale deed has been executed in 1957. 13, lordship can note it down. 13/3/1957. Very important, lordship. 13/3/1957. Now I will take your lordship to the registration of their society when it was registered. Page 223. That society is not existent at the relevant time. Page 223. That is their exhibit. Exhibit Z. Lordship got it? That is of 2008, Lordship. Very important. In 1957, there is no society that Kherapanjal Gaon Unnayan Samiti was there when land was purchased. It was registered in 2008. And Lordship will find they are from their evidence. I can read the evidence, total evidence. That land in question has been purchased on the basis of a resolution of the committee or on the basis of the money given by the people of the locality. Any document from their side that this land has been purchased by the contribution paid by the member of the society. Any document to that effect? No. That land has been purchased from the contribution of this member of the society. There is no document. There is no resolution. Nothing has been exhibited by the appellant herein. That money for purchase of the land in 1957 has been given by the villagers or by the member of the society. Now I will take your Lordship directly to the evidence. Nolini Miki. Cross.
Page number?
Page number, I can give also page number. আমার এটা আছে। Nolin Mikir start from 148. It is SIF. And cross examination part will also find page 159. It is sound. Lordship will
is DW1.
PW1 in DW1. Lordship will kindly see the Assamese version. That will be important. No. Original copy, Lordship. Lordship can see the original copy because translation is not correct. That is their translation. Nolin Mikir, Lordship.
Yes.
Lordship, my age is 34 years presently, Lordship got it.
Yes.
My age is 34 years presently. My year of birth is 1981. The incident prior to 1901 was not some personally seen personally by me, and whatever I'll state relevant to the present suit 1981 are hearsay only. So prior to 1981, he bought in 1981, land purchased in 1957. It was purchased for the society of the villagers. There is no evidence to that effect. That is hearsay only. I know plaintiff as they are resident of our locality. The suit land is 9 biga, 4 katha and 1 lesa. Suit land was as appeared
No,
exhibit co was
you read the original.
Original. I'm reading the original. I'm reading the original copy, Lordship. I have the original copy.
The original is in vernacular.
PW1.
Nolin Mikir.
Nolin Mikir. I'm reading the original handwritten copy.
Nolin Mikir.
Nolin Mikir.
son of late Balaram Meki, age 34 years.
Yes, yes.
Vilas Kipinijol, Betkusi.
Yes.
Again, I'm reading from the starting. My age is 34 years presently.
Hmm.
My year of birth is 1981.
No, year of birth is not mentioned here.
Lordship, then there is two portions
So,
of evidence.
the-
Subsequent cross-examination, Lordship will find subsequent. Because
No,
cross-examination.
this is not
once.
cross-examination.
He was cross-examined not only once. One day it was cross-examined, that is abandoned. Secondly, he was again cross-examined. Date is also mentioned, Lordship.
No, you see this,
It was recorded on 4/4/16.
Recorded by Advocate Commissioner.
4/4/16. আপনার evidence copy আছে?
Certificate কোনটা আছে?
নলিনী মিকির সার্টিফিকেট কোথায় আছে? নলিনী
একটু আছে কিন্তু ইয়াতে নাই it is recorded by Advocate Commissioner maybe in
Hmm?
some other
You find it out from the record. Then let us adjourn the matter. You arrange the evidence of the witnesses. Otherwise, it will consume the time.
okay.
Also fix a short date then. Short date may fix.
So yes, sorted.
Let it be day after tomorrow. After tomorrow.
Day after tomorrow. Possibly, day after tomorrow. So on that day, we will list it top of the list.
Yes.
Okay.
Day after tomorrow.
Day after tomorrow.
Yes.
Okay. Okay.
I may be allowed to check the record, Lordship, by this time in front of that court.
Yes. Yes.
Otherwise,
Yes.
Lordship, it will not be found. That will be difficult.
And you also furnish that judgment to me. That Supreme Court judgment.
Lordship, I have already I have Lordship prepared a list of cases and I will put up that at the time of hearing.
No, especially that judgment.
Lordship.
That decree can be granted
Even
to
for a
the
defendant also.
defendants.
I have not come across it.
Which judgment?
You have submitted that one judgment is
One
there.
judgment regarding Lordship, the point to be determination. That is the first question because the first appellate court have to decide the point to be determined. That is why I have given the judgment. I have given the copy to them.
No, that judgment I got it. The other judgment you had referred in the morning today.
I can give Lordship read this judgment, then I can give the state to the Lordship. But I want to rely. I give the full set of judgment because I finally give the judgment at the time of kind
No,
of.
no, in the morning, Mr. Sodri submitted that without any counterclaim, decree is granted in favor of the defendant.
Yes, Lordship. I can
on-
give the, I will give the judgment.
Okay.
Lordship, in the CPC itself, Lordship kindly see. No, কোর্টে একটা question হচ্ছে
Yes.
Lordship can see order 6 rule 3 where the subject matter of suit is immutable property, where the subject matter of suit is immutable property, plaintiff shall contain description of the property sufficient to identify it. In case of such property can be identified by boundaries and number of record and settlement survey, and plaintiff shall specify the boundaries number and defendant interest and liability to be shown. 5. Plaintiff shall show the defendant is a claim of interest in the subject matter and that he is liable to be called upon to answer the plaintiff's demand. So we can say defendant's right, joint right of the defendant number 1 to 4. I have stated in my plaintiff specifically because it was purchased by the father of the plaintiff and defendant. So joint property we have to disclose. Defendant's interest in the liabilities we have to disclose.
So you are referring to order 6, rule 4.
Rule 4 and 5.
4 and 5.
Defendant interest and liability to be shown. We have shown that we are also 1/4 share of the property, and defendant number 1 to 4 also entitled for 1/4 share of the property. That is a statement in the plain.
Okay.
Obliges.
Timing item number 8, sorry, timing item number 5.
Lordship, have a petitioner is behind the bar last 3 years, 5 months, Lordship. Lordship, out of 8 witnesses, as from instruction, earlier 3 witnesses were examined.
It is a surcited case?
Yes, Lordship, offense report.
How many witnesses were cited in the surcit?
8.
8.
Yes, Lordship.
Out of 8, how many witnesses have been examined?
4 witnesses.
No witnesses.
4.
4.
4.
Is this the second application?
No, Lordship. First.
First.
Lordship, petitioner
Yes.
was-
When the charge was framed?
Yes, Lordship. That was framed.
27/3/2023, Lord.
Yes,
27/3.
23.
Yes. And when he was arrested?
Lordship, he was arrested on Lordship 1/4/2021.
Yes. So the quantity of commercial, no, quantity is commercial?
Yes.
What is the quantity?
9,975 bottles of
1,000?
9,975.
Codeine phosphate?
Lordship, cup syrup, Lordship. NCD.
Containing codeine phosphate?
Lordship.
And whether the witnesses examined till that have implicated you?
Lordship, the official witness, Lordship, one scientific officer, Lordship. PW1 is the scientific officer, Lordship. And PW2 is the Lordship. Is Sri Ramesh Kumar, Lordship, is 43, Lordship. Number 8, Lordship, witness number 8, Lordship.
So this PW 3 is the complainant.
Yes, Lordship, IO.
So this witness has implicated you.
Yes, Lordship. For the offense report itself, Lordship, he is the handyman, Lordship. 24 years ago, he was the handyman. The offense report itself, Lordship. Offense report is start, Lordship, from page 12, Lordship. Page 12 is the offense report. Lordship. Offense report, Lordship, was submitted on 22/9/2021. Charge sheet, Lordship.
No, you see, search it has already been submitted and charges have been framed against
Lordship,
you.
the long delay charge has been framed. Lordship,
So
22/9/2021.
you are not challenging the order of framing charge. You cannot argue on that point. This is a bail application only.
Yes, otherwise, Lordship is behind the bar last 3 years, 5 months, Lordship. Today, Lordship. Lordship, you handyman admittedly, Lordship, in the offense itself, and Lordship.
He hails from which place?
From Lordship, it is
From Uttar Pradesh.
also they are from Uttar Pradesh, but they are arrested, Lordship, in Narayana Hospital near Lordship Amingaon, Lordship. Their Lordship is starting from Rongia side and will go towards the Agartala Tripura, Lordship. Page 13 in the offense report. First paragraph.
So how do you satisfy the requirement of section 37?
There is Lordship, there is a delay, Lordship.
Pardon? Delay.
Delay, Lordship.
Any other point?
Lordship, on judgment of this honorable court
Pardon?
defense.
Pardon?
On grant of bail, Lordship, I would like to submit.
So here the accused was suffering from HIV.
Yes, Lord. Yes. Bail was granted by Meghalaya High Court. Then Meghalaya High Court approached
I am
was
not
opened.
stressing that.
I explained. Thereafter, Lordship, the Meghalaya government approached Supreme Court while criticizing the granting bail. In paragraph 5 to 8, Lordship, Supreme Court observed
Paragraph number?
5, 6, 7, and 8.
So, considering section 34(2) of the Human Immunodeficiency Virus and Acquired Syndrome Deficiency Syndrome Prevention and Control Act 2017, the bail was granted.
That ground was also not considered on also.
Pardon?
On that ground also bail cannot be granted. That is observed by the Supreme Court also in paragraph 9.
No, but that was the prime consideration before the court.
Yes, before the Meghalaya High Court is the prime consideration, but Supreme Court says that no, this cannot be a ground. And Lordship co-accused as approached this honorable court. Lordship has considered all this aspect and rejected the bail of co-accused also. Vision. Lordship, in this case, we file our objection. In paragraph 4 and 5, we have stated about.
No, first let him complete.
Not.
Yes, any other point?
Lordship on judgment, Lordship, I select this of this voting method. Lordship, in this case, Lordship, there were Lordship 12 witnesses, Lordship. And out of 12, 10 were Lordship examined, Lordship. And in that case, this honorable Lordship granted bail, Lordship. Here, Lordship, find Lordship. Paragraph number 6, Lordship.
Yes.
Among other things, Lordship, I file an additional affidavit, Lordship. I have annexed one birth certificate of a child of the present petition. Lordship, what had happened? Lordship, while it was taken custody, Lordship, he was a married person. Lordship, just after marriage, he came to Lordship for his surviving, Lordship, with the drug. And at that time, Lordship, her wife was conceived, Lordship. And in the meantime, while he was in jail custody, her wife was blessed with a Lordship child. Lordship, I have annexed the birth certificate, Lordship. Page 48, Lordship. Date of birth is Lordship 5/12/2021, and he was arrested on 1/4/2020. The young boy, Lordship, actually, Lordship, he had no knowledge about the contrabands, Lordship, and he was only the handyman of that vehicle, Lordship.
So when the last witness was examined?
It lastly in the month of June probably.
June. So from which place the other witnesses hails from?
Except 7, all are from Assam, Lordship. Guwahati.
Guwahati.
Independent are witness from North Guwahati and one is from Chaigaon.
Okay. Any other point?
Lordship, we can a time frame within that period the trial will complete. Otherwise, there's a 3 years, 5 months, Lordship. Only he's behind the bars because the
That's
delay.
right, but
frame, Lordship.
in view of the judgment of Supreme Court in this Allahabad High Court Bar Association case, we cannot issue such direction to complete the trial within a definite period. One of the, after that judgment, one of the High Court has directed the trial court to complete the trial within a definite period. Supreme Court has not only set it aside, but also So, Mr. Kayal, you produced those witnesses before the trial court?
No, Lordship, now after introduction to the new criminal law, we are examining the witnesses through online also. So earlier there was a delay, but now it is taken care of.
Okay, we will see. Third, Mr. A.J. Ahmed, learned counsel for the accused, and Mr. S.C. Kayal, learned standing counsel for the NCB. Argument concluded, order is out.
Much of. Timing item number 8.
With your Lordship, we have taken a step MC 1316 on 9/8/2024.
Third, Miss
A. Hussain.
A. Hussain, learned counsel for the appellant. Office note dated 21/8/2024 indicates that no step has been taken upon respondent number 1A, 1B, 1C, 1D, and 1F till date.
Lordship, we have taken step
When?
9/8/2024. MC 1316.
But the office note is silent in this
No,
regard.
Lordship, but same is not reflected in the office note.
The learned counsel for the appellant, however, submits that step was taken on
9/8/2024.
9/8/2024, but the same has not been reflected in the ordered office note dated 21/8/2024. In view of above, it is provided that Registrar shall put up an up-to-date office note and list the matter after 1 week.
Lordship.
After 1 week.
Mr. K. Gogol was here, Lordship. Now he went to the court number 10, Lordship. He's on next in court number 10, Lordship. So if my friends wants to argue, Lordship, he may argue his part, Lordship. Our part may be heard on next date or any other date, Lordship. Because urgency is in our part, Lordship. We have filed the MFL, Lordship. We have filed the delay condemnation petition. And there is no stay in the order also, Lordship. So they may approach for filing execution petition also. They have not filed that also.
Lordship,
If he wants to argue, Lordship, he may argue, Lordship, because he is on legs, he was waiting here.
Lordship, in this matter, already various adjournment has been prayed by the learned counsel. Lordship, in this matter, repeatedly on the given fixed dates, they are coming and they are taking adjournments. I am just seeking, Lordship, one day this matter be disposed of. It can be disposed of. Honorable Guwahati High Court has itself in various 7 judgments. I've got myself 7 judgment, Lordship. In all the 7 judgments.
No, who is the petitioner? Who is the applicant of this IA?
Applicant,
There.
Lordship, we.
Then who will argue?
From our side, for that, Lordship, we will argue, Lordship.
Then
So,
how can he argue?
So, Lordship, urgency is in our, but Mr. Gogoi, Lordship, he has got the difficulty. He was here, Lordship. If Lordship permits, Lordship, maybe taken up tomorrow also.
Lordship, this repeated adjournment.
Tomorrow may not be possible.
Then, Lordship, day after tomorrow, because, Lordship.
Day
because
after tomorrow also may not be possible in the first week
So-
of September.
As per my friend's convenience, maybe can, Lordship, maybe get it. As
September
he-
first week.
Lordship, in this matter, they are repeatedly seeking adjournments. It is a very serious issue, as has been raised by the Honorable Apex Court. And Honorable Apex Court has in fact imposed cost in various instances in seeking repeated adjournments.
We'll hear you, but we will first hear the applicant side.
Lordship, final date may be granted to them. No adjournments prayer may be allowed in the next date.
Okay, as prayed for by learned advocates of both sides, recess is the matter tomorrow.
Much obliged.
Tomorrow.
Item 40.
Obliged.
Lordship, I wanted to say, Lordship, I have set up the.
Can it be day after tomorrow, Lordship?
Sorry,
Tomorrow, Lordship.
sorry.
I have set
Yes.
up the original record because the evidence and cross-examination part was made by the advocate commissioner. Nothing was in the record regarding cross-examination part of any DW in the record. That is why, Lordship, the trial court has stated then nil. Only one DW was written. Other portion was nil. That is why written. Other portion of the evidence recorded by the commissioner, advocate commissioner, was not there.
Not there. So how can we hear the matter then? Certificate
both the
copies are,
parties- if both the parties
do you
agree-
have the certificate copies?
No, because advocate commissioner, when written the statement, they give copy to the each party. When advocate commissioner recorded the witness statement of the cross-examination part, he recorded and he give copy immediately to all the parties with signature of the parties. We have the copy.
So can we take help of that?
Both the party can give that copy, then it will okay. Otherwise, Lordship had to ask the copy from the Lord Court.
Okay,
I have verified all the record.
we'll take a call on day after tomorrow.
Lordship.
Item 43. So now the case. Second.
My lord, there are 2 IA, my lord. One for condonation of delay of 1024 days, and second is for substitution of the legal years. My lord, since the parties have no objection regarding delay condonation of the opposite party number 1, and your lordship has passed.
Now the council in the morning hours submitted that she will file objection.
Lordship may decide.
Then your this application cost title you have prepared.
The claimant has no objection, my lord.
No, unless and until a order is passed by the court, how can you implement them as party?
There are 2 petition, my lord. Your lordship may pass, as your lordship. 2495 is for delay condonation. I have explained the delay.
So today we will not pass any order. Let it be listed in the first week of September.
My lord.
In presence of both the parties, we will pass the order.
Item 31.
It will recorded
Deadline.
as requested.
Deadline.
He will
Yes.
he will give a date.
31.
This item may be taken on 10th September, my lord. To the
10 September. As spread for by Mr. A.K. Roy, Learned Counsel for the appellant. Having not been objected by Mr. Bhatt, Learned Counsel for the respondent, the SSL is the matter on 10th of September.
Thirty-six.
My your lordship, I am praying for time, my lord.
My lord, the other case, my lord, of 15, my lord, the same, my lord, the defendant was in the lower court, my lord. End of the same area was there, my lord. Two Battle-Nut Garden was there, and earlier one was Battle-Nut Garden, and this one is one Battle-Nut Garden, my lord. Same, the earlier petition also, the first appeal was dismissed on delay ground, my lord. They have again come to the second appeal on the order of the
So when to be listed now?
my lord, on the same day, my lord, 5th of,
When it was fixed earlier one?
5th of October, my lord.
5th of October.
5th of October, my lord.
Okay.
And in this case, my lord, the IA may also be disposed of. It was for early hearing, my lord. Though the matter is listed in hearing.
Okay, we'll heard Mr. M.J. Garid, Learned Counsel for the applicant, and Ms. L. Wazida, Learned Counsel for the respondent. Ms. Wazida submits that this matter may be listed
5th of October.
on 5th of
October,
along with RSN number
149.
149 of 2023. Accordingly, it is provided that SSL list the matter along with RSN numbers also on 5th of October.
All right.
44 and 45.
Lordship, this matter will take some time, Lordship. It's an interstate case, Lordship. Lordship, at this let's fix on any other date, Lordship.
As agreed by learned advocates of both sides, SSL is the matter when
Any Tuesday or Thursday, Lordship, 5th September. 9th or 10th or 13th, 10th, 12 or 10. 10 or 12, Lordship.
September.
September.
12.
Okay, 12 September.
If you
32. 32.
This matter also relates to probate. It probate payment or appeal, intestate appeal. It may require some time, my lord, because it is the first appeal. So, my lord, Lordship may be kind enough to refix the matter
When?
on 17th.
September.
17th of September or 19th,
Okay.
because it may require some time to.
As agreed by learned advocates of both the
17th.
parties,
17th.
SSL is the matter on 17th of September.
Obliged.
46.
May it please your lordships, I am for the appellant. The appeal is for against dismissal, that is order dated 12/8/2016, lordships. Then as per the FIR, as per the charge sheet, and as per the statement of the claimant, that is rash and negligent driving. And 276, 279 and 304A in the FIR also registered and charge sheeted also as per 279 and
You are for the
304A
appellant.
IPC. And it is a summary procedure, and eyewitness is not required because the claimant was from Nalbari district and accident took place in Maranjana under Kamrup district. Proceed, learned.
No, the counsel for the respondent number 1 and 3.
Now not present.
Not
Lord-
present.
Not present, Lord Session. Lordship will be given 10 September.
10 September. Heard Mr. S.C. Pandit, learned counsel for the appellant. So this is for enhancement of the award.
No, against a dismissal. As per the learned member MSCT, that use of the vehicle, not rash and negligent driving of the claimant has been, claimant has failed to establish rash and negligent driving because there was no eyewitness. No eyewitness was produced to adduce evidence. Only for the absence of eyewitness, it was not believed by the learned MSCT. But search sheet and search sheet exhibit 6.
So the
and-
claim petition was dismissed
claim petition was dismissed.
because the accident took place not because of the rash and
National
negligent driving,
but use of the vehicle.
use of the vehicle.
Vehicle.
He was the driver of the vehicle.
Not I am was a Mohori, one of the Mohori, and art filling was done by the dumper. Suddenly kept backward and dashed against me, and I died on the spot due to crash by the rear.
Is it not a rash and negligent driving?
No. And the FIR in the search sheet, in everywhere there is a negligence driving.
So search sheet was submitted under section?
Section 279 and 304A IPC.
Against the driver.
Driver. And there is a paper cutting also there. And instantly on the same day, FIR was lost. 21st December 2011 accident took place. And on the same day, FIR was lost. And on the same day, paper cutting, it was published in the paper, Amar Khobor. ডাম্পাৰ খুন্দাত আজি অকালতে মৃত্যু খাবতি ললে এগৰাকী ব্যক্তিয়ে ঘটনাটো ঘটে ৰংগীয়া মৰাণজান
Yes, sir. Madam, you are for?
My lord, I am respondent number 3, New India.
insurance company.
Insurance company.
As a senior counsel, MSM Chaudhary is not well. He prayed for adjournment, my lord.
Acha. And also heard Miss S. Musahari,
My lord.
learned counsel. For the respondent number 3.
3.
Respondent number 3. Miss Musahari submits that leading counsel Miss M. Chaudhary is indisposed of, and therefore it is contended that another date may be fixed for hearing the matter. Here is accordingly allowed. Recessal list the matter on
10 September.
10 September. Okay.
Obliged.
Obliged.